give the court reporter your name and spell it for the record.
Cindy Littleton Hetzer, Cindy.
This is the motion that Mr. Kelly wishes to pursue in 2024 V0088. And it is a motion to, in regards to new evidence of fraud upon the court. Is that correct?
There were two motions about fraud upon the court, one with new evidence and one addressing fraud generally.
All right. I've got the one on January the 21st, which is the new evidence. Give me the date of the filing of this other motion. I want to make sure it's pending, Mr. Kelly.
It was probably 3 days or 4 days before or after the other motion, Your Honor. I was in custody and county.
Copy of it?
No, sir, I was in custody and I was no longer allowed to fax my motions out. So all of my motions my originals were sent out. And I don't have any of the originals.
Now I've indicated to the court that you've been out of jail for more than 40 days. And, there's nothing that would prevent you from getting access to the clerk's office to get these motions. So I want to make sure that what we're specifically dealing with, Mr. Kelly, for the purpose of the record. So once again, I've got the new evidence. I want to know what is the additional motion that you're saying. When was it filed, and give me the name.
Yes, sir, just give me 10 seconds. I'll pull it up for you. I believe it's entitled Motion for Hearing to Declare Mistrial, filed January 28th, 2025.
All right, and that's one of the motions you wanted to withdraw, and so now you don't want to withdraw the motion for mistrial?
Yes, sir. So on the February 10th was the motion to withdraw.
No, on January the 21st, 2025. Okay, the motion to withdraw. You filed a motion for a hearing to declare a mistrial. And I was under the impression that you had withdrawn that.
we can just proceed. Whatever the other motion is, I'll withdraw it because we can't find it and I don't want to waste any more of the time.
All right, so the motion for hearing to declare mistrial is withdrawn.
If that's not already withdrawn, yes, sir.
All right. All right, there'll be an order entered that you withdrew that. All right, now, that leaves us with the new evidence of fraud upon the court. Are you ready to proceed with that now?
Officer Brandy Crabb has not complied with the subpoena.
All right. Can we see, is she out there or he out there?
Yes, sir.
Oh, he is out there. All right, but you've got Ms. Hetchler on the stand. You want to call him first?
Her, yes, please.
Her? Okay. You step down. Hey, if you'll come and have it, you can walk that way, Lisa. You'll step up and the witness stand, and before you be seated, if you'll raise your right hand for me, please. Do you solemnly swear or affirm the testimony about giving this matter is the whole truth and nothing but the truth, so help you God?
Yes, sir.
You can have a seat. Upon being seated, if you'll be kind enough to state your name and then spell it for the benefit of the court, please.
Sure. My name is Brandy Crabb, BRANDIE,
Thank you, Ms. Crabb.
You're welcome.
Officer Crabb, were you subpoenaed to bring some records with you today?
No.
Your Honor, I'd like to introduce Brandy Crabb's body camera footage as evidence. There are 4 videos from her body camera footage from the night that I was arrested. Do I need to mark those as 1, 2, 3, and 4?
Any objection, Mr. Harrington?
Having not seen them, don't know, Your Honor.
Well, I mean,
Now, he
you
did,
gotta lay the foundation for him, Mr. Kelly.
Officer Crabb, was your body camera footage running the night that I was arrested on November 19th, 2024?
Yes.
Are you aware that the Cochran Police Department has previously provided me with footage from your body camera?
Yes.
Have you watched the footage from your body camera?
No.
I'd like to introduce these 4 videos that were provided to me by the city of Cochran. Mr. Harrington has seen the most important one. I emailed it to him on March 5th.
The question or the issue, Mr. Kelly, is that you've got to lay the proper foundation to get them admitted into evidence. And Mr. Harrington, do you have an objection to at this point?
if he does not lay a proper foundation, which I do not believe he has done at this time, I would object to testimony about the evidence.
Until you lay the proper foundation, Mr. Kelly, the court's not going to admit the body footage. She stated that she hadn't seen it.
So I submitted a subpoena with her subpoena to appear, also with a subpoena for her to bring those with her.
I understand all of that, Mr. Kelly, and I appreciate all of that. But there are still rules of evidence that you have to comply with. And you haven't done so, sir.
Your Honor, I think I'm going to be sick.
I'm sorry,
I think I'm going to be sick. Can I be excused for a moment?
you may.
I'm gonna grab a cup of water, that's.
Just a moment, Your Honor. Officer Crab, I'm sorry, are you ready?
Waiting on you, Mr. Kelly.
Officer Crab, how long have you been with what is your job?
One question at a time.
What is your job?
I'm a patrol officer
Who do you work for?
with the Cochran Police Department,
How long have you been working in that role?
almost 3 years.
Are you familiar with City of Cochran's body camera policies?
That it must be worn on calls, yes.
And was your body camera worn the night of November 19th, 2024?
You already know this. You have the footage. You know it was recording.
Is the answer yes, Officer
Yes.
Crab? And you have provided that footage or it's somebody from the city, or the city of Cochrane has provided that footage to me.
Is that a
To
question?
your knowledge, has someone from the city of Cochrane provided me with that footage?
To my knowledge, yes.
Your Honor, I'd like to introduce body camera footage produced by City of Cochrane, worn by Brandy Crab's, from Brandy Crab's body camera footage.
Yeah, go ahead, Mr. Harrington, your objection.
I do have an objection, Your Honor. That's not the proper way. He should have a certified or certificate of authenticity in order to produce that. This witness has particularly said she's not reviewed it, so she is not aware of what it has on it.
Mr. Kelly?
Yeah, the subpoena was submitted to her to produce that record today.
That's not what my subpoena says.
Okay. And what did your subpoena say?
May I
You
show
have
it to you? I have it in a picture.
Let me look at it. Show it to Mr. Kelly first.
There were two subpoenas, Your Honor, one for her as a witness and one for the production of evidence.
Was she served with both of them?
That's all I have.
Were both given to the Bleckley County Sheriff's Department at
My
the same
question
time.
was very simple.
Yes,
Were they both served on her?
they were both served on the Cochrane Police Department.
Well, she's not the Cochrane. This one is directed to her personally and does not command her to bring anything.
Your Honor, the other one was directed to her as well.
I haven't seen that one.
She says she hasn't been served with it.
How were you served with that document?
I was not there when it was served. It was served to an employee at the Cochrane Police Department, and I was notified via text message of a copy of it stating that I had been served with a subpoena.
What's the name of that employee?
Catherine Helms.
And did Catherine Helms indicate that there was any other subpoenas for you?
No.
Have you got a copy of the subpoena?
I do. I actually emailed it to her and she stamped it.
You emailed it to her.
I'm-
Once again, Mr. Kelly, I'm trying to perfect the record, and there's a lot of hers involved. If you would be specific, that's the only request, that's a request the court has.
Yes, sir. I emailed the request for the subpoena to Christina McCall of the clerk's office to prepare this subpoena for me.
To prepare the subpoena for
And I
you.
came by and picked them up within a couple of hours when she told me they were ready.
All right. Have you got a copy of it, Ms. McCall?
It's probably downstairs, but I scanned them all.
Judge, may I show you this? I just sent Catherine Helms a message since she's the
No,
one that notified me.
No.
Okay.
Was there two subpoenas?
What is this for Cochrane Police Department?
Do what now?
I see one for Cochrane Police Department
See one for Cochrane Police Department?
and for Brandy Crab for another
Which-
one.
there- One's to the Cochrane Police Department and one is to Miss Crabb.
Okay, then I have no more questions for Mrs. Crabb.
All right. You step down. Call you next witness.
I'd like to call Jeff Treywick of the Cochrane Police Department.
All right. Trevor, if you'll step up into the witness box upon stepping up, if you'll remain standing and raise your right hand for me.
Yes, sir, I will.
You solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God.
I do.
You can be seated. Upon being seated, if you'll be kind enough to give us your name And then for the benefit of the court reporter, if you'd spell it for us, okay?
Yes, sir.
All right,
My name is Jeff Trogan, I'm Chief of Police, City of Cochran Police Department.
all right. Can you spell your name for the record?
Trawick.
Thank you. Mr. Kelly?
Chief Trawick, how long have you been with the Cochran Police Department?
28 years and some change.
And how long in law enforcement?
Almost 30.
Are you familiar with your department's body camera footage policies?
Yeah, it needs to be worn when you're on a call,
Was your officer, Brandy Crabb, in compliance with that policy?
as far as I know.
I'm sorry, sir?
As far as I know.
On November 19th, 2024, as far as you know. You were subpoenaed to produce that video.
Is that a question, Your Honor, or a restatement? Because he did not ask the date in particular, just asked in general. And if he's going to come down to a specific date, I think it'd be appropriate. I would object to the form of the question.
Ask him as to the date, Mr. Kelly.
Yes, sir, I was in the middle of asking to the date, and he preempted he answered before I
Asking
finished.
for the date, I didn't need an explanation.
On November 19th, 2024 was, to your knowledge, was Officer Brandy Crabb in compliance with your department's policies on the use of body camera footage and body-worn cameras?
As far as I know.
Were you subpoenaed to produce the footage from her body camera from that night?
The one I received yesterday, I believe. Yes, sir. The reason I did not is because you've already received it twice, and I didn't want to duplicate the process.
So have you reviewed the footage?
No, sir.
Has anybody in your department reviewed the footage?
The only one I believe is maybe the patrol. I don't even know if he watched it. I know he burned the copy, but I don't know if he reviewed it.
Did your subpoena give you the permission to ignore it if it's already been complied with in some other fashion?
I'm sorry, I didn't understand the question.
Did the subpoena give you permission to ignore the request if it had already been complied with in some other fashion?
No, sir, didn't say I did have to either. You received it twice already. That's why I didn't bring it, because you already have it in your possession.
Your Honor, I'd like to move to have Mr. Trawick held in contempt for defiance of the subpoena.
Mr. Harrington?
Well, Your Honor, I think that would be an extreme situation. Even there, he has not provided a foundation yet to introduce the evidence.
Is the body cam at your office?
It's on the server at the police department, sir.
I can't introduce the video. That's why I subpoenaed him.
Mr. Kelly, you have presented a legal issue to me that I'm trying to contemplate,
Yes, sir.
and it's so much easier to do it if you'll allow me to do it without your commenting. We've gone over that numerous times in numerous hearings. All right. Mr. Chief Trawick, I'm going to ask that you go and get a copy of it,
Yes, sir.
all right?
May I have excuse, Your Honor?
Yes.
Thank you.
Is there somebody else that we can entertain as a witness, Mr. Kelly?
Not until the body camera footage has been played. For this particular matter, for the new evidence of fraud upon the court, no, without body camera footage. Oh, Your Honor, sorry. I'd like to sequester Laurel and Max Hetzer. They're not parties to this matter. I didn't realize it just dawned on me that we switched cases.
They're not parties to, the OOAA case.
That is
Be
correct.
sequestered. Y'all can go and sit in the grand jury room. Captain,
Grand-
show them where the grand jury room is. We're not in 012, 0152, we're in 0088.
Yes,
They're
sir.
not parties to that case.
I agree, Your Honor.
Your Honor, I've just discovered that there's something wrong with some of the evidence that Captain Sanders has provided with me. Can I speak to her about it?
You may.
Captain Sanders, can I? So, on this.
Mr. Kelly, do you want this part on the Bradford?
No,
I couldn't hear you.
sorry.
So when you pull it, when you click on.
See, there's no network connection to find it.
Which ones are those? Because they play on mine.
Because you're probably connected to your computer at work. See, if you look, see, here's the, this is the other two discs right here. These are the other two discs, and those are fine. This is the only one that is not. If I can just check this. This was disc 3. I'll show you how you have it labeled here. Is it possible for you to run over and copy this? What the hell? This is the label that you had on it. And only testimony that I need you to is to introduce these audios, these clips.
So 2387 is not on here.
No. And it's likely we're not going to be getting to this today as for evidence, for testimony, so I won't need you, but I will need this created. Can,
Wait a minute, so
the one that's missing.
let me see the other ones I did.
So those two are fine. See, what happens is when you go like this, and you paste like this, you might have accidentally clicked paste shortcut instead of paste.
So which ones are those?
This is 1 and 2. So those are 1 and 2. It's number 3 that's the issue.
Have you got the subpoena? So I can,
So this is the one. This is the subpoena here. So this is the one that's missing.
this right here.
Yeah, well, I'm sorry. No, this one right here is the one that's missing.
How many things did it have on it?
Like 10. It didn't have many at all. There's like maybe 8 at best.
Is this, put it back in there and tell me how many's on there, that way when I get back, I can look at the notes.
And if you can, I don't need you to be here.
Okay.
And the only reason I needed you here was to introduce this evidence, but since it's not going to be heard today.
So how many?
1, 2, 3, 4, 5, 6, 7.
7, okay.
So, and I can give you this. I don't know if you can use it again, but. Appreciate it.
It certainly wasn't my intention.
I'm sorry.
It wasn't my intention.
I know it wasn't. Do you need this?
No, I got a copy of it.
Okay. Tina, you don't need to come back. I'll just come by the jail to pick that up.
Well, I'll go get them right back. Y'all
Okay.
should be here.
Okay.
Your Honor, can I
Can you what?
go put what he requested because it stopped pulling it?
That's fine.
Your Honor,
All right. Go ahead.
I can excuse her. She's here to subpoena to produce that.
The only one that can excuse any witness under subpoena, Mr. Kelly, is the court.
Yes, sir.
And that's the reason she was asking for the court's permission. All right, we have an issue that I just discovered. In light of the fact that Mr. Kelly has now withdrawn his motion to withdraw the motion that we're hearing now, which is the motion for hearing to address new evidence of fraud upon the court. I have reviewed that motion. And that motion makes an allegation that there is new evidence that has come to your attention that I am colluding with the plaintiff to further a fraud upon the court. Are you going to pursue that?
I don't know. I don't remember the motion, Your Honor. I wrote it in jail angry.
Well, I understand, Mr. Kelly, but it makes a difference about how the court can proceed today, and that's the only reason that I bring it up.
I don't know how to address that. I filed 6 motions to recuse you, and you've denied them all.
That's right.
Despite clear evidence that there's not something normal going on. You alternately rule and hear on motions that I have under appeal, even though it's a defective appeal, and you ultimately, you alternate. First, you can't hear it because it's under appeal. Then you can hear it because it's under a deficient appeal. Then you can't hear it because it's under a deficient appeal, and then you can hear it even though it's under an appeal.
Well,
so
Mr. Kelly, I'll submit to you that there are a variety of rules dealing with what I can and cannot rule on or have hearings on when something is on appeal. And in that light, I have to the best of my ability, determine what I could and could not do and ruled in that fashion. I understand that it seems confusing. I will admit that it is complicated, okay? But I have ruled as I understand the law to be. And if you feel that's inconsistent, obviously you have the right to feel that way, but I'm confident in the manner in which I have ruled in those regards, as regards to the appeals.
Okay. There's been times when I've said to myself, what is this man doing? It's clear, like with James Rockefeller, it's clear that he was lying to you over and over and over. He would lie about what he had just filed. He would make a filing and lie about what he had just previously filed. And I would file motions with you because I thought that was the only way to do it. And then it would be 2 months before it was dismissed without being addressed. There's probably 40 or 50 instances where James Rockefeller has lied to you. There's 2 instances.
Mr. Kelly, I'm just merely wanting to understand in this motion that you have now wanted to go forward with after you have withdrawn it, okay, if there is still, are you still going to proceed with this concept that I have somehow colluded with the plaintiff?
I am attempting to answer your question, Your Honor.
Okay.
By laying a foundation.
Okay, I'm sorry. I didn't mean to cut you off.
So all of this that I've witnessed over a year of it seeming like, to me, outside looking in, that you're protecting James Rockefeller from his abuses of the rules of professional conduct. And then there's twice in this case where I say to myself, no, he's doing the right thing. When I filed that motion, I believe it was immediately followed.
That motion, which motion?
The one that you were asking me about, where I addressed.
The one we're hearing evidence on now.
Yes, sir. Particularly the motion or the element of the motion where you're colluding with the plaintiff.
Well, I hadn't heard any evidence in that regard now.
Yes, sir. I'm addressing your concern about my position on that.
Okay, excuse me.
This woman is lying to this court, and the evidence of it is abundant. And because I don't jump over the right heel at the right time and skip the right curb at the right moment, nothing is being done about her lies. Our children's lives are being destroyed mentally because of her lies. No, I do not. I believe that you are acting with integrity since I wrote that motion.
All right, so you withdraw those allegations?
Yes, sir.
All right, thank you. Then we can go forward today.
So, Your
Chief,
Honor.
Chief, are you ready to go forward
sir.
with the chief? All right, let's come back and have a seat.
Yes, sir.
All right. For the purpose of, to expedite where we're at, Chief, the documents and I guess that's a CD,
Yes, sir, it is.
is that copies of your official records?
Yes, sir, it is.
And you just obtained them from the
Yes, sir, I
chief?
did.
Please, I'm going to admit them. They're admitted. How do you have them marked, Mr. Kelly?
I don't know where we're at with my exhibits. If the
Well, let's
clerk-
just mark them as of starting from the beginning today, sir. It'd be easier,
I will mark them all as one.
not all of these records.
There's 4 videos, and they're anywhere from.
All right, let's mark them then 1, A, B, C, and D. Is that 4?
Yes, sir.
All right.
Have exhibit labels if it's of assistance to the court.
Well, it's,
Well, we're gonna play this CD,
okay.
okay? That's what the problem is, Mr. Kelly.
No, I understand that, Your Honor.
Is all 4 of them on one CD?
Yes, all the videos are supposed to be on this one.
Let's just mark it as, defendants 1 to the motion of new evidence. You got that, Madam Court Reporter?
Should I approach the witness, Your Honor?
You may.
Yes, sir.
You're gonna have to, if you're gonna publish it, okay, you're gonna have to come to the podium and hook it up so that we can all see it.
I'm hooked up to the HDMI here. Is that not going to work?
My technical skills are not the best in the world. It would be better if you could play it on the TVs.
Well, that's what I believe this is doing.
Okay, great. If that's what it's doing, that's fine. I'm sorry. I'm not. Tell me when you start it and I'll. Okay, it's ready to be played.
Okay, it's playing the first file. So, on.
There we go, okay.
So Cindy's down there. The office is right down. I'm recording here.
Okay, so the office is this door right here on the left?
Last door on the end, yes.
Right.
So we got our son's medical appointment or a mental health appointment down there.
Right.
And everything's fine, honky-dory. I'm on the phone. I make a phone call to a friend of mine. And I'm on the phone with her maybe like 2 minutes. And I ask her can you get that affidavit ready for me?
Right.
About our custody case. So 6 months ago, Cindy called this woman to harass her.
Uh-huh.
And she's been promising me an affidavit for months.
Cindy has.
Cindy, no, my friend.
Your friend, okay.
So I'm on the phone, and then this happened. So Cindy hears me say, "Can you get that affidavit to me by December 9th?" Cindy jumps up, grabs her phone, and comes over my face like this, and like won't leave me alone. She's trying to get close enough to hear
What she's saying.
Correct. So she stood up now. She's dropped her knitting, thrown it on the floor, and she stood up. She's just off frame. She's about to come over here and like get like right up on me like I'm on you.
Right.
Making me super fucking nervous.
I understand.
I get up and I leave. I go to the other side of the room. She follows me. I cross the room 3 or 4 times. She follows me. She won't let it go. She won't leave me alone. She keeps wanting to stick the camera in my face to film me. There's audio. It's just music. So I pick up my phone, the one that's recording, and walk back across the room and see she follows me right back across the room. Like this far away from me.
Right.
Unnecessarily.
She's close. Correct.
How it made me feel, what the substance of the conversation was. This is me talking to Nicole. She's asking to remind her what needs to be in the affidavit. And so I go outside.
To me by like December 9th.
And she follows me
to get
the
away
door.
from her.
And then she follows me to the door.
Does she actually come outside the
She's
door?
standing right there, like it's wet, so I didn't want to go all the way.
Oh, yeah.
So it was raining, so I'm just standing on the awning. All right, yeah, they most likely, if you go to the tax assessor's office.
Okay, and that's just you talking about that.
And then I go back in, I go across the room, she follows me back across the room.
All this while y'all's child is in there with the
No, they're
counselor?
in the counselor in the back room.
Yeah, they were in the counselor with the,
Correct.
at the time while y'all were sitting in the lobby?
Correct.
Okay.
And see, she just won't stay away from me.
Yeah.
The judge found her in contempt last week, and now she's being extra.
Okay, do you have a TPO against her?
No,
I would advise you to do that.
I've tried. The
But-
judge won't give it because there's no imminent danger, so the judge won't grant it. But this is not appropriate behavior.
It may be where,
She's triggered that so there's 5 or 6 people that she contacted that submitted affidavits. This is the one that hadn't submitted an affidavit. So she was stalking me. She was calling my bosses, calling my employers.
Right.
Calling everybody to say what a piece of shit I was because I broke up with her.
right,
I'm sorry,
right.
who was this?
I'm semi-familiar with the stuff that's been going on with
Yeah,
y'all.
can I get some deputy contact, please?
Hold on a second, I'm sorry.
No,
And
you're fine.
and I don't speak to her at all until this is the first time I speak to her. I say something like, "This is harassment." And I'm scared. The only thing I said to her is, it's here, it's recorded. I said, this
Right.
is harassment, and if it doesn't stop, I'm gonna call law enforcement.
Right, right. Oh gosh, did I eat my ink pen? I got it. You know, we all got our favorite ink pens. Okay.
And I'm just, it's unnecessary. And
JOSEPH,
correct. And we've been in there for 40 minutes before this happens.
KELLY?
Correct.
What's your address?
163 Lucas Road, apartment H2.
H2?
Correct.
And what's your birthday?
41575.
And your phone number?
478-461-5529.
And what is her name again?
Cindy, CINDY, HETZER.
Okay, so let me go in here and try to talk to her and find out why she kept walking up on you like that.
Can you pull her out of there so that I can stay in there with the kids? I don't want the kids to see you talking to her if they come out.
Well, I mean, when I pull her out, you can go in.
Sounds good.
How about that? Okay. Hi, Miss Cindy. Hi, can you step out here and talk to me for just a minute, please? Dang, I track stuff in.
Your camera's still on?
Yes, sir, it is. It stays on the entirety of the call. You're welcome. Here, we'll stand over here so we're out of the rain, but not right at the door. Okay, stand right there so you're not getting wet. All right, now what's going on?
I was in there, brought my kids to their counseling appointment.
Yes?
He's been sitting there, talking on the phone, he played with the boy, with Oscar until Oscar went back to jail.
Right.
And then he was calling some friends, I don't even know who he was talking to, but he was talking to a woman who said she was going down to Savannah. He was talking about he might come up to see her, so she's someone local. He asked her what she was doing December 9th, which is the date of our next court hearing, court appearance. I had my recorder going the whole time that we were in there in case there's any shenanigans going on. And then he asked her, she said she was busy, I think. He had like the volume turned up so I could hear everything that she was saying. And he said, would you mind creating an affidavit for when Cindy contacted you in April?
Right.
And I didn't contact any of his friends in April. He has lied to the police and to the courts that I have. This woman was like, sure, I guess. And then she was like asking him what she should put in in the affidavit. So I got up with my phone and I walked across the room to be closer to the conversation so I could hear it. Didn't look at him, didn't talk to him, didn't touch him. I was like facing away from him. And he's recording me the whole time with his video camera, which is a violation of the protective order. And then he turned to me and said, this is harassment directly to me, which is also a violation of the protective order. And he said he was going to call the police. And then he did.
Okay, all right, I understand about the violation of the protective order, but you getting up from your seat, going next to him is also a violation of a protective order.
And which part of the protective order? is
The
that
protective
violated?
order where you can't contact him or be around him either.
That's
That's
not
why
what
I
the protective order
asked
says.
him, how were y'all able to be up here
Right, that's not what the
together?
protective order says.
But I'm telling you, by law, just because you took the TPO out on him doesn't give you the right to walk up on him and do whatever you want to do.
No, ma'am, I agree with that.
I mean-
There's no distance requirement in the protective order, which is how he's able to be here.
Okay, well, I was kind of curious about that, and he explained the same thing that you just did. And I did suggest to him that maybe y'all can figure that out about bringing the babies up here for counseling. I mean, I'm not...
I would love that. I mean, it's my parenting.
Right,
my
but
parenting time, and I've
what
asked
I would
him,
advise,
He doesn't.
no matter how much it may get up under your skin or whatever, do not walk up on him. When y'all were both here, it needs to be civil. You're here for the babies. Let's put our emotions to the side. And so what if he's on the phone?
It's not about him being on the phone. It's about him trying to get me in trouble with the
Okay,
court.
so what? So what? If you know you've done nothing wrong, so what?
He
Let
lies to
him.
the court, and the court believes him. And I've
Well-
gotten in trouble with the court. I had a good conduct warrant signed but not issued. I'm not even sure what that means from the magistrate's office.
I'm not sure
And it's
either.
because he lied the entire time, and specifically about this sort of thing, that I had contacted some of his
Right.
friends, where he's harassing his own friends and then blaming it on me and telling the
Right.
judge that I'm harassing him.
Right.
He's having him write affidavits. I didn't do anything. I have no
Right.
idea who this person is. I've never contacted them, and I
Right.
need some kind of proof
And,
as to
and
what he's doing.
you stand up for yourself like that, but I'm not saying that you can or cannot record him. I'm not saying that about either one of you. It's a public place.
Right.
There-
Well,
there's,
he's not allowed to record me according to the protective order.
okay, well then you don't need to be recording him, but I understand your
That's not what the
reasoning.
protective order says.
Okay, well, you need to go back to the magistrate and get clarification on that. Because
It's clear
just
the magistrate's office
because,
says that he cannot record me, but it does not.
just
specify. I
because
can't record
you
him.
have the TPO on him does not give you the authority or right to approach him. Oh, I'm sorry.
That's
Are
all
you?
right. No, that was just an alarm that went off here.
I apologize. I'm telling you this for your well-being. That could in return look bad on you when you do go to court. That's why I'm telling you this, to help you out.
I didn't come up on him. He says that I thrust it in his face. He didn't do
You were
that.
very close. I saw the video. You were as close to him as me and you are.
I mean, it's a small waiting room. I walked.
I understand, but you had no reason to get up and walk across the room to him just so you could hear better and record better.
Okay.
I mean, you get what I'm saying?
No, not really, but I understand what you're telling me, and I won't do it anymore.
Okay.
I believe that I have the right to record and defend myself against somebody who's lying about me
Okay.
to all the judges, the
Just,
courts,
but
and the
then
police
just
in the
sit
land.
there. Sit right there where you were at.
Yes, ma'am.
Don't speak to him. Same thing I told him.
haven't.
And I know you
He's been
hadn't.
speaking to me.
And
And I would like to have some sort of a consequences for him speaking to me and recording me today, because he is not permitted to do that. I can show you the protective order where it states both of
Okay,
those
and it
things are not
shows
allowed.
the only time he spoke to you was to tell you to get back from him.
And what about
It's
the
all
recording?
recorded.
What about the recording?
Okay,
He's not
that
allowed
I need
record
to,
it.
that I'm gonna call as soon as I walk
I
away
can
from
show
you.
I can show you the protective
Okay, I'm
order.
gonna call the magistrate to clarify on things. And I believe you're a
Magistrate's
paper.
office doesn't help me. They refer me to the Superior Court, because he's suing the magistrate's office.
Okay, well, I need to speak to someone higher up than I am with the courts, not with the police department, but with the courts. Because I know y'all have there's a lot of dynamics going on in between you and him. There's a lot of stuff. And I just want to make sure that things are handled appropriately.
Yes, ma'am.
Now, he has the whole recording of the time he was in here. I see you approaching him. You're following him. You're standing at the door when he comes outside to talk on the phone.
I did
And
not
then,
stand at the door.
yes, you did. I saw the video.
I stood inside the door. I was
Yes,
not
yes, no, you didn't come outside. No,
I
no, no,
told
no,
you
no,
that I
no.
followed you outside.
No, you
twice.
followed to the...
On the 911 call, he said that I followed him outside.
Okay, well, he did not tell me that.
Well, on the 911 call, he lied to them.
He did not tell me that, so that's... A lot of people lie to 911. I'm not really concerned about that. I'm concerned about what transpired when I got here and talked to him. But give me just a moment, let me go call, and let me see what our course of action. That's okay.
Okay.
All right, and if you want to, you can go back inside. I'm not gonna make you stand out here in the rain, or unless you just want to stand here. That's up to you.
Go inside.
Okay, I'll be right back, okay?
You held the evidence open for this tape to be entered, and it was given to you. I'm not seeing any new evidence, and of course, the motion has to show that there's new
I'm gonna
evidence.
let it play.
Yes, sir.
I disagree with what you're saying, Mr. Harry.
Yes, sir.
This was being withheld.
I'm letting it being played, Mr. Kelly.
Hey, I need your advice, and I have my body camera on. Okay, I'm up here at the hospital in reference to Joseph Kelly and Cindy. They were here bringing their children to counseling. Joseph was sitting on one side of the lobby, Cindy on the other side. Joseph is talking to someone on the phone. He's also recording Cindy sitting there. He said he's doing this to protect himself. Cindy gets up and walks across the lobby over to where he is, and she's recording, standing close enough to him that she can record video and sound of what he's talking about on the phone. He gets up, moves across to the other side of the room. She follows. He eventually gets up and steps outside of the door to talk, and he's standing under the awning outside of Joey's office, out of the rain, talking. You can see Cindy standing on the inside, but at the door. She has a TPO against him, supposedly for recording or anything like that, too. Do you know, in a situation like this, is that grounds because he was recording her to do anything to him legally, or?
I would have to call Carol because I don't know what all the verbiage in that TPO is. Who's working for the county tonight?
Chandler and Hunter.
They should have a copy of it in the squad room.
Because, see, what she's doing, what I feel like she was doing, is she was baiting him. And the only thing he said to her is, "You are harassing me." And she's bringing up that he was recording her and he spoke to her.
I would see what the actual TPO says because I can't answer for Superior Court.
Okay, so call Chandler and see if they can bring me a copy of it up here.
Yeah, see if they have a copy of it. I'll try to call Carol, and if she can send me anything, I will forward it to you.
Okay, yeah, because I'm wanting to handle this, and I know as an officer we can't put our opinion out there, but she was baiting him. She was trying, she was the pursuer in this. And I told her, just because you took out the TPO on him does not give you the right to do those things to him.
Right. Well, if you don't want to be around him and you're scared of him, why are you making a point to go up under, around him?
Yes. But she said that she was recording to, so she could take it to the courts and show that he's been lying.
Well,
line,
He shouldn't be recording her, but she shouldn't be antagonizing him is how I would perceive it, but,
yes, they're both in the wrong.
yep. But let me call Carol, see if you get it from Chandler or Dwayne, let me know, but I'll see what they have.
All right, let me call one of them.
Okay.
All right, thank you.
Happy birthday.
Thank you.
Okay,
Bye.
talk to you later.
All right, bye. Hey, do y'all have the TPO order ready? Like, y'all have it available? What'd you say? Is it? Oh, shoot. Hang on, I gotta get my computer pulled up. And I got my body camera going. He was recording her because she kept walking up on him, so he started recording. And he will move and she will follow him. But she's wanting something done to him because he was recording her and told her to quit. He told her to quit following him because that was harassment. So she's wanting something done because he was recording her and spoke to her. Say what now? Yeah, she was the aggressor in here. He was on the phone talking to somebody and had that person on speaker, and she was on one side of the lobby, he was on the other side. She gets up from where she's sitting and goes across to him and is standing next to him, recording him and recording what he is talking about on the phone. They are up here for the children. The children have counseling. Okay, I can't pull, my computer's not pulling up.
Your Honor,
I
the relevant portion of this video is already come and gone. I don't know if you want to play through the whole thing. If that's the procedure, then we'll play it, but
You can stop it whenever you like, Mr. Kelly.
okay, so
It's your evidence. You're through?
I'd like to highlight the relevant portions of the video for the court.
Well, let's take one situation at a time, okay?
Yes, sir.
Do you need to play any more of the video so you can highlight anything further?
No, sir.
Mr. Harrington, do you want the whole video played?
No, sir.
When we have closing arguments about this, then you can highlight to the court, Mr. Kelly. But I mean, if you're finished playing what you need to play, then we can stop.
I don't have any further questions for Mr. Trawick.
Well, the issue is, what's going to be put into the record is what you play. And so, are you through playing what you need to play?
Yes.
Okay. All right, you're excused, Chief.
Thank you, Your Honor. How about the incident report, Your Honor? Would you like this?
I have it, but I don't need it introduced. I needed you to introduce it to the court. That's why I subpoenaed it.
Okay,
I can't introduce the copy you've already given me.
okay.
All right. Are you admitting the police report?
I'll admit it, Your Honor.
All right. Objection?
None.
All right, it's admitted. We'll make that P2 or D2.
If I may ask for
Sure.
a point of clarification. He said there were 4 parts to this, so we're not looking at the other 3 parts?
That's the other two, we're not watching parts 3 and 4, 2, 3, and 4, or B, C, and D, I guess would be better to.
So for the sake of fraud upon the court, it's only contained in there's another segment. The issue is she committed perjury and said she wasn't recording, and yes, I don't need to play them, no, Your
All
Honor.
right, that's what we're trying to make sure. So as far as the record is concerned, what has been played to this point is all that you want admitted into the record.
Yes, sir.
Okay. Does that clarify it, Mr. Harrington?
It does, Your Honor.
All right.
And for
Madam
the,
Court Reporter, you understand that?
Yes, sir, I do. I do.
Okay.
so the file that we played ends in 0157 for the record.
I mean,
0157.
all right, the chief is excused.
Yes, sir.
Thank you, sir. Yeah, give that to the court reporter.
Yes, sir. Thank you, Your Honor.
Thank you.
And this is the CD that he presented. I don't need it.
Yeah, you need to give it to the court reporter. All right, what else, Mr. Kelly?
I'd like to call Mrs. Hetzer.
All right, Ms. Hetzler. Ms. Hetzler, you've already been sworn in regards to this matter. I will remind you that you're still under oath, okay? All right.
Why were you holding your phone up when you were being interviewed by Randy Crabb?
I don't have any reason. I didn't even realize I was doing it.
Your Honor, I'd like to introduce 2 screenshots from that video. One from the 3-minute, 11-minute mark, or 3-minute and 11-second.
Well, Mr. Kelly, you can try to get them admitted, okay? You can't just say you want to admit it and that's it. But understand this. It appears from what you're saying that evidence is duplicit, meaning it's already on the video,
Yes, sir.
okay? So you don't need to present it again.
Can I refresh the witness's memory with this?
Well, I don't know that she says she hasn't recalled.
Okay.
I mean, I'm not trying, Mr. Kelly.
Okay, Your Honor.
I'm just, you can ask her a question, and if she doesn't recall, then we'll deal with her lack of recall.
Thank you, sir. You received a subpoena to produce a recording that you made at Joey Smith's office on December 9th. Is that correct?
I don't recall exactly what the subpoenas, there were many, many subpoenas, but I've complied with all of them to the best of my ability.
Were you recording during the incident at Joey Smith's office?
Part of it, yes.
What part of it were you recording?
I don't recall when I started the camera, and my phone turns off the recorder anytime that the microphone or the speaker is used, or if there's an alarm that goes off. So I don't know exactly what was captured that night.
So you previously stated you only started recording, your testimony on February 10th was that you started recording after you heard me on the phone.
I don't know if that's
Your Honor,
true, and that's not
respectfully.
a question.
Hold on just a minute.
I'm going to object. He did not call her for cross-examination. I do fully understand she's a
I'm
party.
going to allow it.
Yes, sir.
The objection's overruled.
Your previous testimony to this court was you did not start recording until I was on the phone and you got up to record that interaction.
I don't recall that.
What did you tell Brandy Crabb in that video?
That I've been recording.
Recording what? How long had you indicated you'd been recording?
I don't know.
Can I refresh
Some of it.
the
So I don't
witness's memory?
Yes.
I need volume, Your Honor.
If you putting it,
Yeah,
what are we doing, Mr. Kelly?
I'm just going to play the clip where she says, "I've been recording the whole
Gave the
time."
disc back to the court reporter.
I have that clip segmented out. I can get the disc
We
back.
use
Yes,
the
sir.
official record, Mr. Kelly.
Friends, I don't even know who he was talking to, but he was talking to a woman who said she was going down to Savannah. He was talking about he might come up to see her, so she's someone local. He asked her what she was doing December 9th, which is the date of our next court appearance. I had my recorder going the whole time that we were in there in case there's any shenanigans.
How long had you been recording at that point?
I don't recall. What I said to her was the whole time, but I don't know at that time if it was the whole time that you were on the phone. I didn't, it wasn't like I knew exactly how long I'd been recording.
Can you see the video there? What's in your hand?
It's a cell phone, Joseph Kelly.
And what is that at the bottom of the cell phone?
I can't read it.
"56 minutes and 26 seconds is what it says.
Your Honor, respectfully, he could ask, but he's not testifying right now.
You can ask a question in regards to the specific amount of time, Mr. Kelly, but you can't testify
Yes,
at
sir.
this point in time. Your objection sustained.
You can't read that?
That's correct. I can't tell what those letters are.
Are you ever going to accept responsibility for your actions, Mrs. Hetzer? So we can put this behind us?
I'm sorry, I don't understand how to answer that question. I've accepted responsibility, and I haven't done anything that I haven't been appropriately reprimanded by the court for.
You lied to this court, didn't you?
No, I did not, but you have many, many times.
Were you aware that your attorney had been giving me legal advice?
Your Honor, at this time, I'm going to interpose an objection. Mr. Kelly has previously told me he was going to introduce our telephone conversations when we were trying to work out either settlement negotiations or resolve discovery disputes. These were done while he was in jail. He called me. I responded to him. I can't tell you what everything in the conversation was, but I would state in my place that if I'm trying to resolve discovery disputes or possibly settle this case, that none of that is appropriate to be entered in evidence, nor questioning my client. He has withdrawn, well, the court's ruled that he's not going to
Well,
entertain.
the court didn't allow the filing of that motion. But your question was what, Mr. Kelly?
Are you aware that your attorney was giving me legal advice in this case?
I'm not aware that that ever occurred, no.
I'm going to allow the question and the answer. But you're not going to get to dig too much further, if at all, Mr. Kelly, in that regard.
Your Honor, if I may, the plaintiff has on numerous occasions offered communication between myself and her attorney, James Rockefeller, particularly on August 29th, 2024, and again on September 20th, 2024. In this record, beginning on page 27 and page 689 of this record, Mr. Rockefeller selectively used
What record is that now?
2024 V-0088HCK, the case that we're on right now.
you say a record, and that's what I'm trying to understand.
The clerk's record,
Oh, the clerk's, what's been filed with the
what's been
clerk?
filed with the clerk.
Okay.
So on communications between, Mr. Harrington is arguing that communications between us during settlement negotiations are not admissible. This is not, so OCGA
Well,
24
what his objection is, I believe, is that she doesn't have knowledge of what the conversations were between the two of you. She's testified that she didn't know that there was such conversations. So she can't testify as to what those conversations were. Now, whether I let you get into that when you testify or not, Mr. Kelly, we'll have to decide that at that point in time. You follow what I'm saying? Was she a party to the conversation?
No.
Okay. I mean, how can she testify about what you and Mr. Harrington talked about if she wasn't a party to it?
How are you going to feel when you learn that he was giving me legal advice?
I don't believe that occurred.
What are you going to do when I prove that it has?
I guess we'll see when we get there.
Your Honor, I'm going to object to the relevance of this. If we're here about new evidence, this is not new evidence. It's a completely different issue that's not before the court today.
We're also addressing fraud upon the court, Your Honor.
Well, I'll entertain it just for the sake of entertainment.
Yes, sir.
Have you ever agreed to change the children's name during these proceedings?
No, only during negotiations, which are not admissible.
Okay, Your Honor, I'd like to introduce this letter from James Rockefeller from the plaintiff to me on June 10th, 2024.
And for what purpose?
Fraud, to address her fraud, Your Honor.
What, I mean, I understand, but what fraud are you trying to establish, Mr. Kelly? That's what I'm trying to understand. I've ruled about the children's names. You know, what you contend had occurred was not part of the record for me to rule on. And so because of that, okay, the record being void, I made a ruling. And that, I don't see where that's new evidence.
Okay, Your Honor, I'm finished with this. She's not going to admit that she was recording the whole time. She's not going to do anything.
You've established evidence.
Okay, so I have no more questions for Mrs.
And I'm
Hetzer.
going to weigh that and make a decision on that, Mr. Kelly. Any examination, Mr. Harrington?
No, sir.
All right, you can step down now. Call you next week.
I don't have anything else. I don't have anything else, Your Honor,
In regards to this motion,
in regards to that motion, Your Honor.
okay. Argument, you got the right to open and conclude, Mr. Kelly.
There are over 13,000 frames, video frames, in the interview with Cindy Hetzer at 30 frames per second. And not all of them are clear. They're all blurry. But if you go through them each one by one by one by one, you eventually see that she is recording the whole time. When she says, "I've been here recording the whole time," 58 minutes and 43 seconds is on the timer. A minute before that, it's 56 minutes and 33 seconds is on her timer, her recording timer. That's what that is. Mr. Harrington made a big deal about it on February 10th, accusing me of not being able to see what was on her phone. You mean you could see what was on her phone? Yes, I could see what was on her phone. I testified that she was antagonizing me, calling me names for 30 minutes beforehand. And while I was in jail, I was relying on her being honest and producing that recording. But instead of producing the whole recording, the 58 minute and 41 seconds at this particular moment, she produces a recording that's less than 8 minutes long. I believe it was like 7 minutes and 37 seconds long. And she says that's all she recorded. In the final video, she tells Brad Childers, yes, again, I was recording throughout the entire.
Wait a minute now, we're gonna talk about the evidence, Mr. Kelly, and you didn't go into the final video.
And I regret it because I thought she was going to be honest and she was going to be caught red-handed.
Mr.
And
Kelly,
yes, sir.
The rules cut both ways.
Yes, sir.
And you're not able to argue facts that are not into evidence, okay? And
She lied to this court. She defied the subpoena to produce the record, and then she testified about it twice on December 10th and again on December 9th and February 12th. She committed perjury in this court, saying that she wasn't recording the entire time. In that camera, she clearly tells Brandy Crabb, I was recording the whole time. She's showing her camera to show that I'm recording the whole time, indicating to Brandy Crabb that she's recording for 58 minutes and 25 seconds in this.
I got it, Mr.
Okay.
Kelly.
And that's all.
I know I'm not, don't look like I'm that smart, but I got it, sir. All right, Mr. Harrington.
Very briefly, Your Honor, she did testify to that. I have asked her about it, and that is what she had. We did present it. You may remember in the hearing, he declined.
No, I remember somebody saying there wasn't but 7 or 8 minutes of it,
Yes, sir.
and that was you, Mr. Harrington.
Well, yes, sir. That's what I was told by my client, and that's what she presented. And he chose not to go into it at that time.
I think we had issues about whether it was admissible at that time, and it has been admitted now.
Yes, sir. And I believe you held the record open, and before you made your decision, if you don't remember it, I will not
I don't
belabor
think that is the way it went, Mr. Harrington.
Yes, sir.
I remember we left the record open in regards to a certain video, but I don't think it was this video.
Certainly may be wrong. That's my memory. But
I'll review the record before I make a ruling in regards to this matter.
yes, sir.
But, Mr. Kelly, in your closing remarks, what I'd like to know is, let's say that there is new evidence and that there's a fraud upon this court. What is it that you want this court to do?
Hold her accountable.
Well, I understand that, but I mean, what do you want me to do? You want me to reconsider if I can, and I'll have to look at the law, reconsider my ruling in regards to custody? You want me to hold her in contempt and put her in jail?
Sir,
What is it what relief do you want?
your ruling on custody is the best choice for my children. Hands down, I appreciate that ruling. So far, she hasn't been held accountable for anything. Put her in jail. Put her in county jail for 7 days. And let her know that her lies have consequences. There's nothing that she can do. I mean, that she does what she wants to do because nobody will hold her accountable. Like give her some consequences, have some sort of meaning. That she can't play these games and continue to get away with it without repercussions. Because I've had repercussions. Not all of my choices has been perfect. There's been some bad choices, and I've had a lot of a lot of consequences for some of my choices, some extreme, some that I don't believe fit. But so far, she's had none.
Okay. All right, I'm gonna take this under advisement. There's some legal issues in my head that I need to address and look at. And I'll do that, and I'll get an order out as soon as possible. All right, do we have any other matters today? You need to give the court reporter back to this. Anything else that you want to have heard today?
We were scheduled for matters of contempt that haven't been addressed yet.
All right, you may proceed. You need to tell me which contempt matters they are and what motions are involved.
Particularly matters related to,
And I want
Oh, I'm sorry,
I
sir.
want the specifics, Mr. Kelly, so that the record is complete.
we're also supposed to have a family violence protection order hearing today. Can we start
I
there?
asked you what you wanted me to hear, Mr. Kelly, and I'm here to hear everything
Let's-
you want me to hear.
I'd like to address the family violence protection order.
Okay? All right. What date was that found?
I'm looking, Your Honor. It was filed February 4th, 2025. Petition for hearing to show cause for issuance of a family violence protective order.
And that was in 0088, right?
Yes, sir.
All right, you may proceed.
So Cindy Hetzer has been abusing the legal process to deprive me of my life, liberty, my children. She is vindictively filing police report after police report for over a year now, making false assertions to this court and tell every member of law enforcement she has contact with. And my position is all of that contact constitutes stalking.
All right, so let me make sure I understand. You're saying the pleadings that she's filed in this case or these cases constitute stalking?
Yes, sir. So
Okay.
stalking is any contact, but not limited to any physical contact. Any contact for the purposes of harassing and intimidation. Georgia courts have ruled repeatedly.
But I understand, I do have a little knowledge of the law,
Yes,
Mr.
sir.
Kelly. And what I'm more interested in is appreciating the factual basis for your claim. And as I understand it to be, and if I'm wrong, correct me. I'm just trying to understand, sir. But it's my understanding that the fact that she's been filing these, or the fact that she's filed pleadings in these various cases is the basis for your claim of stalking.
Not the sole basis, no.
Okay,
They
all right.
play a role.
But
in it.
that is one basis.
That is part of it, yes, sir.
All right, what is the other?
Contacting friends, family, coworkers, approaching me in a
All right, slow up now. I'm taking notes. Contacting
friends,
friends and coworkers.
accusing me, defaming me, brushing up on me in a lobby of a waiting room, knowingly making false statements to law enforcement anytime she sees me in public.
Okay.
And a lot of these issues are going to be addressed in the civil process in 152, but they also, I mean, for family violence, Your Honor, I don't know if,
Well, let me, I don't mean to interrupt you, but I want to make sure. But your allegations that you have in this pleading that you have filed on February the 4th of 2025, you have made those allegations to this court on numerous occasions.
not in the context of seeking a family violence protection order, I have not.
Okay. Well, and I'm just trying to recall, Mr. Kelly, because I have a lot of cases in 6 counties, okay? And I'm just trying to recall part of what you've stated in this case in some form or fashion was the court not granting you a protective order who probably sometime May, June of 2024. And aren't these the same allegations?
No, sir, no
Okay.
hearing has ever
All
been
right.
held. That-
Well,
yes.
no, you presented a protective order to me, and I denied it, and that's what I'm getting at. Are these the same allegations?
Some.
Okay. All right, well then, let's just deal with the new ones.
Well, sir, particularly there's video that the court hasn't seen related to these allegations.
Okay, and
So- So far, everything has been my word against her word.
all right, what videos do you have?
There's a video of the altercation where she approaches myself and Ruth Skaggs on April 2nd, where she
And that's the video that I held the record open for,
No,
and
sir. Sorry. I apologize.
Mr. Kelly, I'm trying to be as patient as I can be, and we've always understood that you wouldn't talk over me, okay? But it was my understanding that was the video that was not admitted into evidence because you didn't lay the proper foundation. You're talking about the video that I believe was the basis for her getting the initial TPO against you. Is that not right?
No, sir, that's
Okay.
not right.
Okay, I'm sorry.
So the April 2nd incident
Yes, sir.
is the video that I'm talking about, where she accuses me in her TPO of,
Yeah, that's the one I'm talking about.
no, there's multiple videos, Your Honor. I recorded everything. I recorded all of our.
I understand that.
The one that you're referring to is the February 19th incident that I've been trying to get you to review and get into the record. And
February the 19th.
Yes, sir, when she-
Of what year, sir?
2024, I apologize.
So over a year ago.
Yes, sir.
Okay.
So it was the basis, it was the very first thing that she includes, and this is all a lie. This is her affidavit, and it's all a lie. And this video shows that it's all a lie. And everything that she's done since then has been based off of that incident. And it's between her and I, it's less than 40 seconds. The video itself is 2 minutes and 11 seconds. Most of it's me driving up her driveway and setting up a camera.
Well, the question is, one, do you have the video?
Yes,
And two, evidentiary-wise, can you lay the proper foundation for it to be admitted into evidence?
yes.
Okay.
I also have Mrs. Hetzer's video that she recorded, and you recall she presented screenshots. I believe it was Plaintiff's Exhibit 2 or 3 or something, where she lied about what they showed, but I have that video as well.
All right, and that's what you want to present to the court in regards to this motion?
I want to show this court that she's a liar.
Well, I understand that's your motivation, but I'm more concerned about the basis for your protective order, okay? And what you're asking the court to do is to grant you a protective order on events that took place over a year ago.
And events that go on now. So what the November 19th incident, if I had been granted a hearing
November 19th,
of 2024.
you're talking about the one that we just saw.
Yes, sir.
Okay.
Had I been 5 times prior to that incident, I begged everybody, law enforcement, I had begged judges, give me a hearing so I can show what this woman is doing, and nobody would hear me. You had scheduled it when we first, when I first came to you on May 10th, and you threatened to arrest me.
And Mr. Kelly, what I told you, that your behavior was such that I could hold you in contempt for your behavior.
And I was begging for help.
I understand, but let's make the record correct, okay?
And so far, the only thing anybody cares about is Joseph Kelly's an ex-con, and here's this poor woman claiming, woe is me, let's protect this woman. And that's all that's been going on from the day one. And I want to lay that foundation. I want her to, if she comes up to me with a cell phone and thrusts it in my face again, I want to be able to be protected. I want her ass in jail. I want her to be snatched up and taken out of her lives and away from her children for her actions.
All right, well, let's present evidence then.
I call Cindy Hetzer.
All right, Ms. Hester, come back to the stand. It's in the same case. I see no need to administer another oath to it. Anybody have any objection?
None, Your Honor.
Mr. Kelly? Mr. Kelly,
Yes, sir.
I asked you a question.
I'm sorry, sir.
This is the same case. Do you see any need for me to administer the oath to her again?
No, sir. Your Honor, this is Mrs. Hetzer, did you file an affidavit with this court to petition for a temporary protective order?
Yes,
What date did you file that petition?
I don't remember.
I'm sorry?
I don't remember.
Court will take judicial notice of the affidavit that's been filed.
No objection.
I don't know that you have the right to object to me taking judicial notice. Mr. Harrington?
You are correct, Your Honor.
Can you please, Mrs. Hetzer, describe our custody schedule prior to April 17th, 2024?
It was about 67:33. You had the boys Mondays and Tuesdays most weeks, except for the third weekend. You had them Friday through Monday.
April 15th, 2024, a Monday, and my birthday at 9 a.m., where were you?
I don't recall.
It's a Monday, and it's my birthday. Where do you think you were? At
I
9
don't
a.m.?
recall.
What do you do at Mondays on my custody days, Cindy?
I don't
This
know
is
if that was the third Monday or the second Monday. I don't know unless I'm looking at a calendar, what the schedule was for custody.
What's the date of your birthday?
April 15th.
Okay.
Does April... Does April 17th sound like the day that the court gave you a protective order?
Court's gonna take judicial notice of that protective. What I'm getting at, Mr. Kelly, is I'm not trying to circumvent your examination, but I'm gonna look at that file, and those dates and everything are gonna be as if they came out of the Bible. Do you follow?
Yes,
what-
yes, sir. So the issue, Your Honor, is on a Monday morning at 9 a.m., we're at custody exchange. She knows this, but she's trying to pretend like she doesn't know it.
Well,
April,
hold on just a minute. Is that reflected in, the dates reflected in her affidavit and in that court order?
yes. Well,
Well,
yes.
I'll take judicial notice of the calendar and as to the dates that it falls on. Okay?
So on April 15th, if that's my Monday, you're at Wendy's exchanging children with me at 9 a.m.
I don't recall because there were many times that you refused to bring them to exchange, said you were going to be there, but then you didn't show up. I don't know what happened that day.
On the
I
day-
don't remember.
On the day that you filed for this temporary protective order, were the children in your custody or my custody?
They were in your custody.
So it's safe to say that you brought the children to me
I
prior to filing that protective order?
don't recall. They were not in my custody.
Let's kind of cool it. You're getting a little agitated, let's ask her questions, but let's don't get agitated with her, okay? Take a breath.
You told Judge Michael Johnson that you were terrified of me and you were afraid of what would happen to your children and your safety if he didn't grant you that temporary protective order. Isn't that correct?
I don't believe I used the word terrified. I accurately described events that had occurred and that I was scared of you.
Did you believe there was imminent danger?
I did, yes,
Why did you take the children to me and then go get a protective order?
because I can't take the children with me into a hearing with the judge.
So you would leave them with somebody that you think they're in imminent danger of?
I never said that they were in imminent danger from you. I said I was afraid of you.
You asked the judge to take the children away from me because you indicated that you felt they were in imminent danger. Your Honor, I've given her a copy of her temporary protective order if she needs it to refresh her memory of her affidavit.
I'm not sure what the question was that you just asked.
You petitioned this court saying that you needed the children to be taken away from me in sole custody and so that I have no contact. Isn't that correct?
That's not what my request was, no. I walked in there with the information and the records that I had, and the judge helped me along.
Did you check boxes?
I don't recall which boxes I checked and which ones.
Did the judge grant you an order that took the children away from me?
The order was granted, yes, with a temporary protective order, an ex parte protective order.
Do you think the judge did something that you didn't ask him for?
I never said that.
So you don't know who asked him to take the children away from me?
I didn't say that you are demanding me to admit that I walked in and asked the judge to take the children away, and that's not what I did. You're misrepresenting the facts.
What did you do? What did you ask him for?
Hold on just a minute, Mr. Kelly. Did the order in fact take the children away from Mr. Kelly?
No,
What did the order say?
it changed the custody schedule.
Huh?
It changed the custody schedule.
Right. It prevented him from having visitation, didn't it?
It changed the visitation. It didn't prevent him from having visitation for the fifth,
I
until
get
the
picture,
hearing.
Mr. Kelly, let's go on to something else.
For the record, it did change, it did change everything. It didn't change the visitation schedule. I had no contact with my kids for 18 days.
Your Honor, if that's excuse me for not standing, that's a question, I would like him to rephrase it. It sounds like an argument.
Ask it in the form of a question, Mr. Kelly. Isn't it true that I didn't have visitation with my children for 18 days?
Isn't it true that I didn't have visitation with my children because of your temporary protective order?
I don't recall the time frame that there was before the callback hearing, but there was a period of time where, yes, there was no contact, and that was ordered.
Do you remember? You don't remember. You don't recall what you put in this petition to destroy mine and my children's life. You don't recall this, right?
I'm sorry, I don't know which part that you would like me to answer. I didn't destroy your life.
Your Honor, can I present this to the witness for her refresher memory?
Show it to Mr. Harrington first. All right, for the purpose of refreshing her memory, you can look at that document and respond to his question, Ms. Hess.
Yes, I understand, sir.
You previously testified
Did
that,
she answer the question? Don't ask her another question. You gave her a document to refresh her memory, Mr. Kelly.
sorry,
I'm sorry, I don't remember the question. Could you
All
please
right,
repeat?
restate your question that you wanted her to refresh her memory to, please, sir.
do you remember filing this document with the court?
This looks familiar, yes.
Is that your narrative?
I believe so, unless you've altered it.
Do you have any evidence that I've altered it?
No, I just made a statement and answered your question.
Do you often accuse me of doing something negative when I ask you a question?
No, I accurately state the facts.
All right, we're not going to have a debate about the veracity between the two of you. The court's got a pretty good picture of that, so let's go on to something else. Let's
Yes,
go
sir.
to the facts of establishing your entitlement to a family violence protective order, Mr. Kelly.
Can you look at page 3 there, Mrs. Hetzer? The incident on April 11th. Why did you include that in this petition?
Because it scared me when you asked me to meet you in the woods in the dark.
I asked you to meet you in the woods in the dark. So you said I asked you to meet you in the woods in the dark?
That's correct, yes.
How else would you describe that location?
It was in the woods in the dark between our homes.
Would you call it the property line between our homes?
In the woods, in the dark, yes.
Is it at the property line between our homes?
I've answered the question.
Your Honor, I'd like to introduce screenshots from,
If you're going to use her to do it, she's got to identify it.
Yes, sir.
You got to show it to Mr. Harrington.
I've given you copies of these, sir.
I understand you gave me a mound of copies. I want to see what you want to talk about now.
I also subpoenaed her to provide these. I don't know that she has.
Let's stay on.
These 5 pages?
All right, what are we marking these? Kelly 3 today?
Sure.
Is that all right, Madam Court Reporter? Sir. All right.
Have you ever asked me to meet you at the property line?
I'm sorry, is this?
An improper question until they're admitted.
I'm sorry.
No. It's not an improper question. He can ask her if she's ever been asked to meet, she's asked him to be met at the property line.
Withdrawn, Your Honor.
I don't understand what your objection was, Mr. Harrington.
I thought he was testifying as to the exhibit he just gave her. I was premature. I'll withdraw, Your Honor.
Can you please repeat the question?
Have you ever asked me to meet you at the property line?
Probably. Back when we were together and dating, not 3 months after we had broken up or 2 months after we had broken up.
How many times have we met at the property line, Mrs. Hetzer?
I don't know.
Too many to count?
I don't have an estimate for you.
Did you ask me to meet you on the property line on December 19th?
I don't recall.
You can review the text messages before you and that exhibit.
Well, first off, there's a difference between her recollection being recalled or admitted them as an exhibit.
Okay, are we?
If you want her to look at them to see if it brings back her memory, then you can do that. Or you can see if she can identify those documents and we can make them and see if you can get them admitted into evidence.
Do you recognize these documents, these text messages?
I can't be sure that they're complete, but they do look familiar, yes.
Were you subpoenaed to produce some of these records?
I've provided everything that you subpoenaed me to my lawyer.
So can I have the records that they were subpoenaed? Then we wouldn't have to worry about her accepting that mine are complete. We can use her records.
Ma'am, are those text messages between you and Mr. Kelly?
I believe that they are, yes.
All right, they're admitted. And I'm getting very weary, Ms. Hetzler, of the dancing that you're doing.
Why wasn't it a dark and secluded place when you're asking me to meet you there?
Because it was 8:15 a.m.
What about the next day?
That was 9 a.m. in the morning.
Are we broken up during this time frame?
February 6th, we had broken up February 2nd.
December 19th, we were broken up?
I'm sorry, there's several different text messages here. So one of them was February 6th. December 19th, I don't know if we were broken up. We had broken up some of the December and November. I don't know of those days.
So how about on February 19th? February 19th. It's the last 2 pages, Mrs. Hetzer.
Yeah, I brought the boys over. You didn't come to the property line. I walked the boys to the property line, and they walked to your door. And you demanded that I come to your back door, and I refused to do that because I didn't want to be around you.
Are you sure that you walked the... Why don't you read the text messages, Mrs. Hetzer?
What I did was I offered to walk the boys over.
Okay,
And asked you-
You were deathly afraid of me at this point, right? February 19th, you were deathly afraid of me?
I would like to make some clarifying statements without interruption, if that's okay, please. The
Your
property.
answer is questions, ma'am.
Yes, sir, I'm trying to. The property line is probably from here to the corner of the courtroom, between the property line and your back door. And it's very far. Probably even farther than that, actually. So I wasn't going to be around you if we had exchanged the boys, as we had discussed in this text message. You were going to be at your house, and I was going to walk them to the property line and then watch until they went into your back door.
You're asking me to meet you to get the jars.
No, I asked you
Your
to
Honor,
please send them back with the boys.
Well,
I said, can you
Let me
please send
see-
one of the
let
boys
me
back
see
out
what
with them?
they say. They've been a minute.
Excuse Excuse me, sir, he's mouthing
No,
curse
sir.
words at me.
Ma'am, I'm telling you, I'm getting very weary of your behavior. All right, which, in this exchange, who says, "I'll be there at the property line"?
She does.
I didn't ask you, Mr. Kelly, I'm getting a little weary of you.
I said, I'll be at the property line, yes.
It was a dark and scary place only for the purposes of this protective order, isn't that
It
correct?
was 8:30 for this discussion, and they were going to be coming at 9.
Mr. Kelly, I think you need to go on to something else.
Okay. I eventually brought the boys to your, or came to your house to pick the boys up, isn't that correct?
You did drive to my home, yes, to pick up the boys.
And that incident was recorded, wasn't it?
You recorded it? Yes.
And did you record some of that incident?
Only after you started driving your car towards me, or it seemed to be that you were about to drive your car towards me.
I'm sorry.
I restarted recording whenever your vehicle began moving towards me.
Your Honor, I'd like to introduce Mrs. Hetzer's recording of that incident.
Well, before we do that, let's verify that it is what it is, meaning what she's got to identify it.
So I don't know, you want me to take a computer over there to play it for her so that she can identify it? I don't know.
She's got to say that's her recording. If she does that, then we can play it for the court.
So I'm going to approach her and play this video for her, Your Honor?
I'm sorry?
I approach her and play it for her so that she can verify it's hers?
I'm not, or you can, let me ask you this, Mr. Kelly. Was this video played at the initial protective order?
No, sir. She presented screenshots that I'll get to in a minute.
I paused.
Okay. Are you ready to view it?
No, I'd still like to finish it. I just
Okay.
didn't want to move.
How long is this video?
This is 30 seconds, Your Honor.
Oh, okay. Mr. Harrington, if you review it and you don't have any objection, the court would appreciate your letting the court know that so we can just go ahead and play it.
Yes, sir. I have no objection.
All right, let's play it. Submit it without objection. Or, Madam Court Reporter.
Sir.
I don't know that you got it.
I've got it queued up, Your Honor.
I don't know that you do. It's not in the system.
There it goes.
Still not playing, Mr. Kelly.
I'm ready. I was just waiting for you to say go.
Do what, sir?
I was just waiting for you to say play.
I'm waiting on you, sir.
I'm not sure why there's no audio, Your Honor.
All the audios is up.
Yes, sir. It's up on my machine.
Hold on just a minute, Mr. Kelly. It's not showing up on this monitor. You know why? Hang on just a minute, Mr. Kelly. Marlon, can you come see if you can?
I can try the other computer, Your Honor.
Well, I want to see the video. Or I don't know if I'm doing something wrong or. The one you used before worked perfectly.
Yes, sir, I can switch back to that
So
computer
let's
if you'd
do
like.
that then. Well, hold on just a minute, Marlon, let's make sure I. All right, now it's working for some reason, Mr. Kelly. Okay, well, thank you. Okay.
I don't know why, I don't know why it's not playing audio. Can I try another video to see if another video is playing?
No, so this is the video that's been admitted, so that's the one that we have to use.
I just want to use a video to test the sound, to troubleshoot, Your Honor. I can play the Officer Crab video that's already been
That'll be
admitted.
fine.
So it could be that the video that she gave me has no sounds. That's the video that they provided to me on Discovery and February 10th, I believe.
That is a video of somebody driving a car.
That,
Is
Yes.
that your car or you're driving it?
that's me driving that car.
All right, let's play it one more time for the court, please. And the date of this incident,
February 19th, 2024,
and you're driving down her driveway or your driveway?
her driveway.
Okay.
That's the exit of her property.
Okay. All right,
Mrs. Hetzer, you wrote in your petition for temporary protective order that I began driving on the grass. Do you see that? It's about 8 lines down from the February 19th.
Okay.
I was continuing to move backwards, and then I stopped because he was continuing to drive toward me on the grass. Did you write that?
Yes, I did.
And you said you weren't sure what I was going to do.
Correct.
And you said I drove right next to you, very near to your body.
Yes, you did.
Did you walk towards my vehicle at all?
No, I did not.
You
And
did
that's
not
what you've
walk-
lied to the court over and over again.
I
My
don't have-
feet were on the driveway. Your hand was pulling the wheel this way as you were holding the GoPro with the other hand towards my body. And when you cut in front of me, I was in the middle of my driveway. My feet were in the middle of my driveway. And my driveway curves towards the road, and I submitted that photograph to the court last hearing.
Yes, you did.
Yes, I did.
So in that.
There's your hand.
Are those exhibits here, Your Honor?
do what, sir?
The exhibits that she presented, that she's referencing now?
The question is,
Are those exhibits available for this hearing?
are they filed in that TPO file?
No, they were submitted on December 9th.
In regards to this matter?
Yes, sir.
Madam Court Reporter, do you have all the exhibits?
I do.
All right, find it, I'll look at it.
Do you know the exhibit?
No, I'm talking, Mr. Kelly, you find them.
December 9th.
Yes, ma'am.
All right, let's deal with them at the court reporter's table, please.
Sorry.
To save time, may I approach and do watch it at the same time?
Well, it's my understanding these are exhibits that's already been admitted.
Yes.
This is it right here.
Okay.
These 6 photographs.
All right, you want to show them to her? And whose exhibits were these?
These were her exhibits, plaintiff's exhibits, Your Honor.
All right.
May I approach the witness? Because my labels are usually not green. Those are plaintiff's exhibits.
Were you questioning the integrity of the court reporter, Mr. Harrington?
No, sir. No,
Well,
sir.
they came out of the court reporter's evidence or exhibits files.
Your Honor, I
I
wasn't.
take it that you were.
No, so there's a green label on that. Mine are usually yellow, and that's all I was.
But my point is, it came directly from the court reporter out of her envelope.
Yes, sir.
And so, to me, you were questioning the integrity of the court reporter.
Respectfully, no, sir.
All right, let's go on.
You previously testified that you did not select these screenshots, that your attorney selected these screenshots.
No, I never made that testimony.
Who selected these screenshots?
I did.
You did?
Yes,
And did you print them out?
I did.
Did you give them to your attorney?
I did.
Was it this attorney?
I brought him to court. I didn't give him to an attorney. I brought him to court and pulled him out whenever we were discussing this situation.
This attorney?
I believe so, yes.
And these photos show me swerving my vehicle towards you.
This photograph is not labeled? I'm not sure what you're asking me. Yes, in this photograph, your hand is pulling the wheel all the way towards the right, towards me, with one hand, with your left hand, and with your right hand. You're holding a GoPro while you drive your car towards my body.
Thank you. Can you go to the image, the other image of my wheel? That you testified that these show me turning my vehicle towards you. Here it is right here on the screen, Mrs. Hetzer. Here's the wheel right here, Mrs. Hetzer, up on the screen, Mrs. Hetzer. You said I'm turning my wheel to the right. You said I'm turning my wheel, right? Here it is right here.
Yes, you're turning your wheel in this photograph right here.
Can my hand be on the steering
I don't
wheel
have a
without it being
photograph of your
turned?
wheel being turned, but I have a photograph of your hand turning the steering wheel.
Here's the video right here,
Sure.
Mrs. Hetzer, of all the frames, Mrs. Hetzer.
Excuse me, sorry.
She could see it.
My wheel never turns. My wheel.
Ask questions, Mr. Kelly.
Can you stop me when you see my wheel turn towards you, please?
I don't have a photograph of your wheel turning, but I have a photograph
here.
of your hand turning the wheel.
All right, let's go on to something else.
Is it possible?
Mr. Kelly,
Yes.
let's go on to something else. I've got the concept.
You testify, or you stated in this affidavit that I approached you in the street and was screaming profanities at you. Is that correct?
What date?
On April 2nd.
I'm sorry, I don't see April 2nd. Do you have the page number? Oh, yes, I see it. What I said was that as Ruth passed me, you said she's crazy twice, and I believe you also used an expletive. I said, I believe you also used an expletive during the second instance.
I yelled loudly.
That was my recollection, yes, at
Yelled?
the time.
Okay.
Yeah.
Your Honor?
And whenever you played your video for the court, I do believe that you may have edited that video with your professional editing software. That's your job, is editing video and photographs.
What video did I edit?
The one where, in the street, April 2nd, that we're talking about, sir.
Do you have evidence of that?
No, I don't. I
Okay.
just said I believe that it was edited, because it's not as I recall.
So, Your Honor, I need to call her. I'd like to. I have no more direct examination for her. I'd like to recall her on cross after I testify.
Well, Mr. Kelly, you need to go ahead and ask her the questions you need to ask her, please.
I need to introduce a video of her walking that related to that incident. And she's not going to say that she's not going to admit it into evidence. So if
All right, I'll consider your request at the point in time that you make it, but not at this point in time. And I'm telling you, I may not grant it.
I would like to introduce a video of Cindy Hetzer's encounter on April 2nd.
All right? Can this witness identify it?
She's in it, Your Honor.
How long is this video?
Less than a minute.
Have you seen it, Mr. Harrington?
I have not, Your Honor.
All right, show it to Mr. Harrington.
It's 10 seconds, Your Honor.
Any objection, Mr. Harrington?
I have no objection showing to her. If she can identify it, that's fine.
Any objection to the video itself?
No, sir.
It's omitted. This will be 5. Go ahead, Mr. Kelly.
You're crazy. Do you think it's acceptable to thrust your camera in people's faces as you walk in by them?
I don't believe that it's any problem whenever I was trying to get a photograph of her, because you had said that she was going to be picking up our children for an exchange, and I hadn't seen her, I hadn't met her, I didn't know what she looked like, and you said she's crazy right in front of our children.
Why didn't you just introduce yourself to her?
Because you do crazy things like say I'm harassing your friends.
Okay, Your Honor. I don't have any more questions about that incident. Now I'd like to introduce my point of view of the February 19th video. The show-
Well, you can do that when you take the stand,
Okay.
Mr. Kelly.
Then I have no more. Are we on the family violence right now, or are we on the contempt?
We're on the family violence thing, Mr.
Then I have no more questions for Cindy Hetzer.
Examination, Mr. Harrington.
Professor, I was not your attorney during that time, but did he file any counterclaim to the petition for protective order?
I believe he did, yes.
And was this covered in the counterclaim?
I don't recall.
All of this existed prior to the February 25th, April 25th hearing?
It did,
So this has all been considered by the court before?
many times. Every time we're in court.
Okay.
All right, she testified that he did file a counterclaim.
Well, that's what she said, but I'll be honest with the court, I did not see a counterclaim file.
Well, that's my point. She testified that it was filed, and I don't see one being filed either. And that's the reason I'm asking you to direct my attention to the one that she claims was filed.
Well,
No, sir, not well. Tell me where I can see it in the record.
I don't see it in the record.
All right, very good.
I'll wait for
Ask your
it.
next question.
That's all I have, yeah.
You can step down, ma'am.
I'd like to call Deputy Rios if he's available.
Who?
Deputy Rios.
Deputy Rio?
Rios, yes, sir.
I need those two videos.
Yes, I've got a thumb drive for you. Can I give it to you at the end?
Yes, sir, that's fine.
The point I was trying to make, and I'll make it an argument.
He's being called, Your Honor. All right, can you call somebody else? It's 4 o'clock.
Yes, sir, I can call myself, I guess.
All right. Come up here and testify then.
Is it possible to testify from here?
What did I just get through saying, Mr. Kelly?
Your Honor, I really also have to pee. Is it possible to take a
We'll take a break. We'll take a 10-minute break.
Yeah, you can go to the law library. Grand jury room, that's where your husband is.
Need something, huh?
You didn't take them somewhere.
Everybody else is here, sir.
In a minute. Where's Mr. Harrington? 10 minutes is up.
Sorry, sir.
Mr. Kelly, the deputy, is here now. Do you wish to have him testify first?
Yes, please.
All right, let's have the deputy come in, please. You'll come up here and, when you reach the witness box, if you'll stand in there for me for just a second, raise your right hand.
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
I do.
If you'll have a seat, state your name for the record, and then for the benefit of the court reporter, if you'd spell it for me, please.
My name's Abel J. Rios, ABEL, initial JRIOS.
Thank you.
And what is your job, Mr. Rios?
I'm a deputy sheriff with the Bleckley County Sheriff's Office.
And how long have you been in that position?
Just over a year,
And how long have you been in law enforcement?
give or take almost 20 years.
Are you familiar with Bleckley County Sheriff's Office incident report policies?
I don't see how that's relevant. I typed the report, so there's this incident report system in place, so yes.
So do you comply with those incident report
Yes.
policies? So you're familiar with them and comply with them?
Yes.
Did you have a chance to encounter me on April 17th or April 22nd, 2024?
I have a report listed for April 22nd of 2024.
Did you review that report before coming here today?
I have the copy of the report with me.
Outstanding, thank you. Can you describe what that incident was about?
Basically, you walked into the LAC to report a false statement. When asked, you said you wanted to provide some information regarding false statements made by Miss Cindy Hetzer.
And did you review any evidence before you conclude or made that report?
The only thing that I believe at that time was the video that you sent. I can't remember if you had the copy with you or you had emailed me because I asked you for the email be sent with that video. But based on that information, it describes, I'm sorry, I'm backtracking. Based on your statements, according to that video, that you began driving on the grass, this is what she said, and I continued to move backward, and then I stopped because he was continuing to drive toward me on the grass, and I wasn't sure what he was going to do. He drove right next to me, very near my body, and then he cut his car over in front of me onto the driveway. I felt very afraid, and I immediately sent him an email telling him to not enter any part of my property again, and that we need to exchange at Wendy's for all exchanges from then on.
And did you view evidence that contradicted Mrs. Hetzer's assertions?
Based on the video, what I saw in the background was that you had walked around the vehicle to the right side passenger door, you knock on the passenger door.
I'm sorry, Mr. Rios, me or Cindy Hetzer?
I apologize, Mr. Kelly. Exited your vehicle, you opened the left rear passenger door, got out, and went back into the driver's side seat. And I saw in the background that you walked around the right front passenger door. You knocked on the door. There was something inaudible said. Then you placed the vehicle in gear, start to drive off. As you are driving off, Ms. Hetzer is walking down the driveway as you are, the same driveway as you are, and then you are seen maneuvering away from Ms. Hetzer.
So the video that you saw doesn't show me swerving towards her?
Correct.
That's only all the questions I have for you, Deputy Rios.
Cross.
No questions, Your Honor.
Thank you, sir. You're excused.
Thank you, sir.
Call, you want to come on up, Mr.
Yes, sir.
Kelly? If you'll,
The computer up here, Your Honor.
I don't know whether you need it or what. I mean,
I mean, I need to play a video to introduce the video.
all right, you will bring the computer up here. Well, I tell you what, let's just let you testify from there because I don't know that you can hook up with the system down up in the witness room, witness box. All right, raise your right hand for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
I do.
All right, you may proceed.
On February 19th, Cindy had instigated a fight over some mason jars. And I didn't want conflict with her anymore, so I just decided to go and pick the boys up and not engage with her any further. I get to the property, I know there's going to be conflict, so I set up a camera in my car. Once I put the boys in the car, she approaches me aggressively, asking me where the jars are. I ignore her, I get in my vehicle and start to leave. She walks around my passenger side, she bangs on my window, not taps, not knocks, she bangs on my window, repeatedly demanding, where are my jars, where are my jars? My children are seeing her behave this way. I put the car in drive, and I see her walk away and stand in the middle of the driveway so that I can't leave. She has a history of doing this, blocking my exit from arguments. So I slowly drive around her, and as she sees that I'm driving around her, she starts walking towards my vehicle to close the distance between herself and my vehicle, as the deputy described. And I'd like to introduce that video of that incident.
You seen it, Mr. Harrington?
No, sir.
How long is the video?
It's 2 minutes.
All right, let's let him see it.
Do you want to take it off of the big screen while we do this?
No, sir. That's not the way we do it, Mr. Kelly. We've done it several times now. He's got to look at it, and then I've got to see whether he's going to allow it to be admitted. No, sir. Take it off.
That's what I asked you, if we wanted to take it off of the big screen.
I said, take it off. I thought you said, do you want me on the big?
No, sir, I was asking if you wanted me to take it off.
Take it off. Okay. All right, this is 5, Madam Court Reporter. 6, okay. 6 is admitted. You can play it, Mr. Kelly.
Are you ready, sir?
I said you could play it, sir.
Knew that once once people get used to it, they're not going to want to go back.
Wall Street Journal technology reporter Christopher Mims, thank you so much.
Thanks so much for having me.
In New York, I'm Sabrina Benishore with the Marketplace Morning Report. From 8 p.m., American Public Media.
From the campus of Mercer University, this is 89.7 FM, WMUM and WMUM HD, Cochrane-Macon, part of the Georgia Public Broadcasting Radio Network.
You've been listening to Morning Edition on GPB. I'm Pamela Kirkland. Thank you for joining me this morning. Stay with us for the BBC NewsHour coming up next. Have a beautiful day, and we'll see you right back here tomorrow.
Support for GPB programs comes from our listeners and Georgia State University. GPB Atlanta is licensed to Georgia State University, the largest university in Georgia and one of the largest in the nation. More information is available at gsu.edu. Georgia has such a rich history and continues to grow and change. GPB offers you diverse stories with diverse voices you won't hear anywhere else. We'll show you the wonderful places and people in the state.
Welcome to NewsHour from the BBC World Service. I'm Rebecca Kesby. Today, a defiant stand. Alexei Navalny's widow Yulia accuses President Putin of killing her husband and calls for supporters to keep fighting his regime.
The most important thing we can do for Alexei and for ourselves is to go on fighting. I will continue Alexei Navalny's work, continue to fight for our country.
A Western journalist tells us of his encounter with Russian special forces behind the front line in Ukraine.
There was this huge bang on the door and shouts, and these special forces guys stormed in. And I think this is Russian humor, but they started talking about eating my liver.
Plus, we'll have more on the latest EU attempts to take on big tech, this time Apple.
After I left her property, I was looking in the rearview mirror, and she continued to follow me down the driveway as I left. That's visible in her version of the video, where she continues to chase me, to film me, and yet she reports this incident as she's afraid of me, and that I swerved to hit her when she's clearly walking to my vehicle, and I'm trying to get away from her. She's made a big deal that I parked perpendicular to the driveway. I did that so that I was visible, she was visible, and the children were visible when they approached the vehicle in my camera's view, so that there was no chance that she could argue something happened that didn't happen. And I don't have any more questions for myself about this incident.
Cross-examination, Mr. Harrington.
Mr. Kelly, you were present at the hearing that was held on April 25th?
I was.
You had an attorney?
I did.
You had an opportunity to bring all these matters up at that hearing?
I did.
And that was at a hearing, and this was all done in the court system?
I don't know. I don't think I understand your question.
You have stated that there were a lot of things that she has done that you complain of. This and everything you've talked about today was through the court system, correct?
Correct, but this is the first time that the judge has been able to witness this video compared to her testimony about this incident.
I understand, but you're here today asking for a family violence protective order.
That's correct.
But everything, are you acknowledging and agreeing that everything has been from court litigation?
No.
Okay.
It has not. Not from the perspective of me petitioning for a protective order. This is the first time any of this evidence has been presented as family violence against me.
And there's been any family violence that you're suggesting, what has occurred after the Judge Wall's order granting her family violence petition?
A number of things, Mr. Harrington.
But you haven't testified to him today. Have you presented anything other than the waiting room incident.
Good point. I'll
Postdated.
address that on redirect, Mr. Harrington.
He's asking you,
Have I? Yes.
what else have you presented other than?
Today, you're right. I naively believed that this is enough evidence to prove this woman lied to obtain a protective order.
Understand, we're not here about that today.
No, I understand.
We're here about issuing you a protective order.
Yes, sir.
What has she done to threaten you after the ruling by Judge Wall in April of 2024?
She falsely reported to Deputy Ruiz that I pointed my camera right at her. You have since made a filing saying that she mistaken it. That's what she believed. But when she testified to that officer, she told him, no, he definitely pointed his camera right at me and my daughter. And then in your filing of March 13th, she's walking that statement back. Do you want me to go on, or do you want to ask me questions about that incident?
And what about that made you in fear of your life, health, or physical safety?
Because she's abusing the legal process to have me arrested. Her goal is to have me arrested and put in jail, affecting my mental status, my psyche, my relationship with my children.
Understand that in a family violence, I don't want to educate.
So you don't lecture him, you ask questions, Mr. Harrington, you know better than that.
Yes, sir. So what physical act has she done that made you in fear of your life, health, or physical safety?
There doesn't need to be a physical act, according to the laws of the state of Georgia, for stalking to occur.
What physical act has she done that has placed you in fear of your life, health, or physical safety?
She's made a number of false reports to law enforcement. She's invited her 16-year-old daughter to also make false reports to law enforcement. Those are physical acts.
Okay, are you in fact in fear of your health or physical safety?
Every day. Every day I'm afraid of what she's done now. Every day.
Okay.
I don't sleep. I'm dreadful afraid.
Of what?
Of Cindy Hetzer's lies and her manipulative behavior.
I'm asking you, what physical harm are you afraid of?
Her manipulating the courts and her manipulating law enforcement.
All right. Now, in the course of you defending and or prosecuting these various civil cases, have you in fact also asked questions of and talked to people that she's had as witnesses?
I don't understand your question.
You've tried to talk, for instance, to the pastor.
What do you mean I've tried to talk to him?
Have you tried to talk to anybody that she's held as a witness in any of these cases?
No.
None.
She hasn't called any witnesses in this case. And that's the problem. It's been her word against mine this whole time. And there's a slew of evidence that she's lying. And attorneys come in and they mangle words and they twist things to pretend like she doesn't remember. Just say you don't remember and it'll be okay. Just say I don't recall. Just say you don't recall, Cindy. That's all you need to do.
And what's more, I'm asking about things that are not in the court system.
Perhaps you could ask me a question about a specific witness and I can answer. But she has not called any witnesses to testify in this case against me. To answer your question directly.
Do you not think it's prudent for her in preparing for your witnesses to ask them questions?
What are you talking about?
Have you been physically harmed? I understand you're talking emotional. Have you been physically harmed at all by Ms. Hetzer?
Yes.
Describe with particularity what physical harm you have been subjected to.
She has pounded her finger into my chest when I try to walk away from arguments with her. Repeatedly, from 2019 to 2023. Repeatedly. She wants to tell me something, she's gonna tell me. She won't let me leave her property until she's heard me or until I've heard her.
And since 2023, has that happened or occurred?
No.
Okay.
But Georgia courts have also recognized that psychological abuse and emotional abuse is just as damaging as physical abuse.
Have you had to go to a doctor, physician, or counselor about it?
Yes.
Who, when, and where?
Would you like to submit her name is Miranda, and she's the County Behavioral Services out of Dublin.
Time frame?
Time frame? I don't know. I had my first in-person meeting with her last week.
Okay. Although you say none of these physical behaviors have occurred since 2023?
Yes, sir.
Okay. And are you suggesting that the psychiatric harm is part of your case against Ms. Hester?
Yes.
So will you waive any conflict or privacy issues with your counselor?
I don't know what you're asking me.
Can I have all of her records in discovery?
And let's go on about the facts of this case, Mr. Harrington.
That's all, Your Honor. I'm sorry, if you'll give me just a minute.
I'd like to introduce
Hang on just a minute, Mr. Kelly. Let me get through with Mr. Harrington.
Sorry.
That's all, Your Honor.
All right. Now what, Mr. Kelly?
I'd like to, he pointed out that I hadn't pointed out any sort of harm that's come to me, so I'd like to address that.
All right. You may testify and redirect based on the issues that he has just raised to you.
So I'd first like to introduce a video of me journaling. And this is following.
You doing what now?
Journaling, talking, describing my feelings, my thoughts.
No, sir, that's
It's related to Mrs. Hetzer and her.
I understand that, but that's perpetuating. If you want to say the same things now, you can, but you can't introduce who are you talking to?
I'm talking to Cindy.
Oh, you were talking to her when you made these remarks?
Yes, sir. It was a video journal intended for her.
No, sir, that's not what I'm talking about. Was she present when you made these remarks?
No.
You're not going to be able to bolster your case by something. You can testify now about what you said, but you're not going to be able to use that video.
It's not about what I said, Your Honor, but it's about my emotional state. It's a visual representation of the harm that she's caused.
And once again, you're not going to be able to do that. Anything else? That's a little bit self-serving, Mr. Kelly.
Well, he indicated that I haven't suffered any
I
harm.
understand that, Mr. Kelly, and I'm giving you an explanation of why I'm not allowing it.
And I've accepted it, Your Honor.
Okay. Anything else?
Yeah, so I was walking. No, I don't have anything else, Your Honor.
All right. Anything on recross?
No, sir.
All right. You got any additional witnesses in regards to this matter?
I'd like to recall Cindy Hetzer.
All right, Ms. Hetzler. Remind you you're under oath, ma'am.
Yes, sir.
On February 19th, 2024, were you walking towards my vehicle as I was driving?
No, I was walking down my driveway.
No further questions, Your Honor.
All right. You step down. Anything else?
No, sir.
Mr. Harrington, you have any evidence you wish to present in this matter?
Ms. Hetzer, I would remind you, you've been sworn. Excuse me, Ms. Kelly. Ms. Hetzer, I remind you, you've been sworn, and I apologize. Have you physically threatened Mr. Kelly in any way?
No,
He talked about you pointing in his chest. Did all that occur before 2023?
the incident that he's referencing was in 2019. There was one incident.
Tell the court your belief or memory of that.
What I remember is that he was getting onto my kids, and I told him to stop yelling at my children. And we were fighting, and he shoved me into a couch. And when I told him that that's not acceptable, he said that if you call the police, I'm going to tell them that you were poking me in the chest with your fingers, and we're both going to jail.
Have you stalked him?
Never.
Have you physically threatened him?
No.
And have you tried to use the court system to protect yourself and the children?
To protect myself and the children? Yes. Yes.
What, if any, self-help remedies have you attempted to do?
For myself?
Yeah.
I'm in counseling once a week. I've tried to get the children counseling.
But everything you've done as action has been through the courts?
Action towards him? Yes.
That's all I have.
Anything on recross
Do you remember testifying, I'm sorry, yes, Your Honor.
or cross, excuse me?
Do you remember testifying about that incident in 2019 at your temporary protective order hearing?
I don't, no.
Can we give her the transcript so we can refresh her memory?
I didn't bring anything up about the transcript, but
You brought up an incident, she's already testified.
You brought that incident up.
She testified about that incident already, and she didn't say that.
He brought it up, it's fine.
Where's it at in the transcript, Mr.
I'm
Kelly?
going to give it to you right now, sir. Do you embellish, Mrs. Hetzer?
No, I don't try to embellish anything, no.
Your Honor, I'll find it and I'll submit it to the court.
No, sir. It's today or never.
All right.
Mr. Kelly, we need to move on. It's 4:45.
I'd just like to submit that she testified something different now than she did on the 25th. It's going to take me, there's 1,100 pages of documents.
I understand, but
I'm-
there's a
I'm not-
matter of preparation. If you knew you were going to ask her about it, you could have had it available to you. We need to move on, sir.
I didn't ask her about it. He brought it up.
I understand. We need to move on, sir.
Okay.
What else, if anything, do you have?
Our son ran away from home one day, didn't he?
You have two sons. Can I have an appreciation of which one?
Oscar, our 5-year-old son, ran away from home, didn't he?
He did.
How long before you discovered he was gone?
I believe it was about 20 minutes, but I'm not sure.
How did you discover he was gone?
When the police pulled up to my house.
Who directed the police to go to your house?
I believe it was you, but I'm not positive about that.
What was your reaction when the police came to your house asking you about your children?
Respectfully, Your Honor, what does this have to do? I would object to.
Where's the family violence in this?
It's her exaggerating things. When she's told that her son has ran away, she tells the officer, I don't know that he didn't lure him off the property.
That's incorrect, and I'd like to testify.
It needs to relate to some felony or the alleged misdemeanors that constitute family violence, Mr. Kelly, and I don't see it.
So stalking, Your Honor, it's contact.
How is her response to law enforcement stalking to you?
Siebert versus State. Siebert was arrested for aggravated stalking because he sent a letter to the protected party's
Go
attorney.
on to something else. I'm not going to allow it. Let's go on to something else.
Okay. I don't have anything else for her.
Anything, Mr. Harrington? You
No.
Step down, man. Any further evidence?
I'd like to call Deputy Benjamin Shepard.
Present.
I don't think he was in school today. I don't know if he's here. He's out of town.
What about these other folks, the priest and?
Let me verify.
That was for contempt. They're here to testify about contempt, Your Honor.
And how long are those hearings going to last?
It depends on how many people say, I don't remember and I don't recall.
Okay.
Sergeant Shepherd's not available, Your Honor.
Okay.
Can Jeff Simpson introduce the video that he provided with me?
That who provided?
I subpoenaed the Buckley County Sheriff's Department for Benjamin Shepard's body camera footage. He presented that to me at the start of this hearing.
Pursuant to the subpoena?
Yes.
Do you have any objection, Mr. Harrington?
I just don't know what it is.
Well, I understand that, but I'll show it. How long is that video?
It's like 30 minutes, but there's only like a 30-second clip that's relevant. It's when she tells the deputy, I don't know that he
No,
lured
sir,
him
I
up.
didn't ask you to testify about it. I asked you, how long was it? You gonna play a 30-second clip,
Roughly 30 seconds, yes, sir.
and you know where it's at? We
Yes,
don't
sir, I
have
should be able to
hunt
find it. Yes, sir, I should be able to find it pretty quickly.
I'll show it to Mr. Harrington. Court's inclined to admit it because it came directly from the sheriff's office as part of their records.
Yes, sir. Your Honor, I am going to object because it's the very same incident you just directed him to move on from. This is apparently the interview that the officer is talking about the child that ran over at his house. And I would still say
Is that
it's
right?
not relevant.
She just testified under oath that she didn't say this.
Is it the video of the officer dealing with your son having ran away?
Yes.
All right, I'm not gonna allow it. Let's call on something else.
I'd like the record to reflect that she perjured herself, and this video shows that she
No,
did.
sir. We're going on to something else, Mr. Kelly.
I don't have anything else, Your Honor.
All right, we need to have argument in regards to this matter. You got the right to open and conclude, Mr. Kelly.
I'd like to reserve.
All right, Mr. Harrington.
Your Honor, respectfully, he started out by saying that there was a whole lot of things going on, including specifically court records. As the court is aware, there is a mixed bag here, but things that are done in court are not actionable per se, except for what the court may do in sanctions in that hearing. I will tell you, quite frankly, I looked to find out whether there is any case law saying that you're required to do a compulsory counterclaim as far as the petition for protective order that was done on April of 2024. The code section does require, if you're going to make any response or bring up any defenses, you should do it 3 days before the final hearing.
I'm familiar with the statute.
I would argue that that is tantamount to a compulsory counterclaim, and all of these things he's talking about, with the exception of the waiting room incident, in fact occurred prior to that hearing, and I
Yeah,
would think.
but my thoughts are the fact that the waiting room incident occurred, does that circumvent his ability to show her behavior, previously? Maybe not, what I'm getting at is not base the protective order on the incidents that occurred during the period of time that she was getting the protective order, but the subsequent acts, are enough when you take in the cumulative facts of what she's been doing all along.
And I, of course, agree that that was in the court's purview. But I would argue a lot of these things in his suggestion that he's been in physical fear of his life, by his own testimony, ended in 2023. It doesn't meet the near time standard.
Well, I don't know, and I'll have to look, but I don't know that it's necessarily requires fear of your physical harm. I think it also requires or can deal with one's mental harm.
Now, addressing the incident in the waiting room, by his own testimony and by his own videotapes, they are in a very small contained waiting room. He sets up a camera after he's been ordered not to. and he engages in a public phone call to someone to arrange testimony or witness testimony in this case. He certainly could have done that any other time, and I would suggest that he is baiting her by doing it in her presence.
And I have a lot of problems with your client's testimony dealing with the length of that recording that she made and her veracity of this whole situation, Mr. Harrington. I'll be glad to hear from you to address that, the court's concerns.
Well, I presented what I was provided, Your Honor, and that's all I can say.
I didn't put it on you. I'm talking about
Yes, sir.
court's perception of her veracity of misleading this court or what appears, I'm gonna look at it, appears to be misleading, that she said it was a 7 and 8 minute tape and it was some 50 some odd minutes of tape.
All I can do is disagree based on what my client has told me, Your Honor. Now, at least in that 7 minutes and what he has presented, he clearly baited her into trying to record it.
I understand that that's your position.
Yes, sir. Now, I think it can be handled in a different manner than a family protective order if the court chooses to add to its open case and do a restraining order. She is a federal employee. I asked the court to take into consideration the effect it would have on her ability to support the children if a TPO is entered. And I know the court understands the distinction because we've dealt with that before.
Sometimes life falls where it falls, Mr. Harrington.
Well, if the court should see fit, I would respectfully request that you consider doing it as a restraining order in the main case rather than a TPO. And even if the court feels she has acted inappropriately, the fact that he is not contributing now because of his affidavit of indigence, she's the only breadwinner these children have. They need somebody to be able to work. A TPO would end her ability to work for the federal government. I know the court is aware of that. I will leave that at that, but I would respectfully suggest that I don't believe he's presented evidence today. That is, of course, up to the court. But if the court should see fit to have some sort of restraint, I would request that it be in the form of a civil matter, not a TPO, because that is a special animal requiring registration with
I'm very familiar with them. I
Yes,
do them on a daily basis,
Yes, sir.
or at least a weekly basis. Some weeks daily.
Yes.
Mr. Kelly?
Your Honor, every incident that she describes in her family violence protection order occurred to a certain degree. She adds language to make it seem nefarious, like meeting her at a dark, secluded wood, where that's where we always meet.
We can't relitigate that.
I'm closing, Your Honor.
For what?
I thought I was making a closing argument, Your Honor.
But I've got, it's 5 o'clock. You're telling me we got some more hearings we're gonna have to have. I'm not gonna inconvenience these witnesses. They've come again from Savannah or wherever. And so I'm just telling you, your argument is not proper because those matters have been litigated and there's been an order issued.
Mrs. Hetzer lied to obtain a restraining order. She lied, and she's repeatedly done things that had put me in fear of my safety. She sat there for 35 minutes while my son was in my lap, calling me pathetic, desperate, loser.
What evidence did we have today about that? Let's talk about the evidence that's been presented today, Mr. Kelly.
She recorded for 58 minutes and then refused to turn that over because it showed that she was committing the instigating incident. I didn't begin recording her. I never recorded her. I never stated that I recorded her. I was very aware of that protective order when I set my camera up to film me, to film myself because of her behavior in that waiting room. I filmed myself like I did in my car to protect myself from her allegations. I did it with the spirit of the order in mind. It was 4 minutes into the phone call before my friend brought up the court date. We weren't talking about anything related to Cindy Hetzer until she asked me when the next court date is. How's it going? I'm not responsible for how she responds to me saying something. I wasn't attempting to bait her. Maybe it wasn't the best. Maybe I should have said, let's talk about this another time. Maybe I should have, but it doesn't justify what she did. She did what she did because she's had no consequences for a year. And for Mr. Harrington to argue that please don't give this woman a family violence protection order because it will hinder her ability to care for her children and provide for her children. They didn't care that they took away my ability to care for and provide for my children with a family violence protection order based on lies.
Address the court, Mr. Kelly, not Mr.
Based on lies.
Well, the issue is what Mr. Harrington is bringing up is that I can do the same thing under an injunction as I can under the Family Violence Act. The injunction doesn't go to the extent that it could possibly affect her ability to work. And that's, what he's saying is she has a family violence protective order against her. She may not be able to get on the base.
I have a family violence protection order that's prohibiting me from working in certain areas.
No, I'm not saying that I'm going there. I'm just trying to explain to you what.
Yes, sir, I understand.
Okay.
Her husband has an income of $130,000 a year. They have more than 400,000.
That's not evidence. We could talk about the evidence, Mr. Kelly.
He brought up her ability to provide care or provide for her children. She's the only breadwinner. She's not. Her husband has $130,000 worth of annual income. They have over $450,000 worth of property.
That is not evidence in this case, Mr. Kelly.
Nothing.
And I'm going to refrain. You need to refrain from arguing things that are not in the record. I restricted Mr. Harrington. Same way.
Your Honor, respectfully, Mr. Harrington got to show how poor and desperate and destitute Cindy's going to be if you prevent a family violence protection order against her.
And there was evidence to that effect, but there wasn't any evidence to what her husband made or their assets or anything like that.
Yes, sir. So, I don't want to be here. I don't want to be trying to put my foot on her throat and punish her. I don't want to do this. I don't want her having detrimental things in her life, hindering her life. I don't want it. Every time I back away from her and say, okay, I'm done, she sends me another email telling me how this is all my fault. Over and over and over again, I withdraw.
All right, Mr. Kelly, when you say things like that, are you telling the court you don't want me to issue a protective order?
No, sir. That's not what I'm saying. I'm just saying I want her to stop.
Okay.
And
I appreciate your argument. Let's go on to the next case. All right?
Mr. Kelly, I need that disc.
I'm sorry?
I need the disc. I need 4, 5, and 6.
The disc.
Did you get all your other exhibits back in your envelope?
Yes, sir.
You mean the thumb drive?
If it was on thumb drive, I'm not sure what.
The
it was
videos
on.
that I presented?
Yes, sir. You played three separate videos, D4, D5, and D6.
Okay, I got you. Yes, ma'am. I'm going to delete everything else off of this thumb drive and just give you those 3 videos.
Oh, yeah, you're right about that.
it's frozen.
If it's helpful, Mr. Kelly, you didn't ask for emails, you asked for text messages. And the text messages are on. But if you got them yourself, you can certainly introduce them.
Okay, thank you. I guess I'll call Cindy Hetzer.
All right. This is in the 0088 case.
Yes, sir.
All right. I'll remind you, Ms. Hetzler, that you're under oath. All right, go ahead, Mr. Kelly.
Have you had a reasonable and adequate good faith discussion with me about the religious formation of our children?
I attempted and you refused to have discussion. We've had many, many, many discussions about religion.
Did you address any of my concerns about the baptism of our children?
I attempted to, yes. But none of my answers were good enough for you.
I'd like to introduce a email exchange on the religious discussion between Cindy Hetzer and myself on June 29th, I believe, June 30th. It began on June 29th. It starts at the bottom here. This is the first message, going up to the last.
Let her look at it. I mean, you've done it enough to know how to do it, Mr. Kelly.
If you go to the second page.
No, sir. Ma'am, can you identify that email exchange?
Yes, I believe that this,
No, sir. No, ma'am. It
Yes.
doesn't have to do with whether you believe. My question is, can you identify it?
yes,
Because that's why I'm telling you, I am tired of your dancing. When this court asked you a direct question, you answer it. Do you understand?
yes.
Any objection to the exhibit, Mr. Harrington?
No, sir.
It's admitted, what is it, 7, Madam Court Reporter?
8.
8. All right.
Sorry, just to refresh your memory, just in case you don't. Do you consider that an adequate and reasonable good faith discussion?
Yes.
How many of my questions did you answer?
Your questions weren't about the children or their baptism. They were about me and beliefs that I held previously in the past, years ago.
Do you think your beliefs affect our children's beliefs?
They're not my current beliefs.
So why
Oh,
didn't
no,
you
I don't.
I don't have any more questions about that email. I'll just let the judge read it for himself. Who are Kim and Mike Brocks?
They are the people who were the godparents for the baptisms of our children.
And how do you know Kim and Mike Brox?
I believe we met years ago. We were acquaintances for years through my daughter's soccer team.
Is the appointment of the children's baptism or children's godparents a major life or a significant decision, a major decision in the children's lives?
No, I did not consider it so because I didn't know if I knew any Catholics. And when I was speaking to the deacon about this, he said, "Don't worry, my wife can just stand in for that position." So no, I didn't consider it to be a major position.
Does the Catholic faith consider the appointment of godchildren or godparents an important decision?
I don't know, and I've told you how I understood it at the time that I made that decision.
Do you believe differently now?
I don't know. I can't speak for the Catholic Church and what their beliefs are.
I'm not asking you what their beliefs are. I'm asking you what you understand of the Catholic religion.
Can you please repeat the question?
Is the appointment of a godparent a major life decision for a child?
I don't know. Apparently not, because the deacon said my wife can just stand in that day if you don't find anybody else.
Do we have an agreement not to spank our children?
That's in the original custody order, yes.
Why exactly did you start spanking our children?
I didn't.
Your Honor, I'd like to submit another email discussion between her and myself. Do you recognize this email, Mrs. Hetzer?
Your Honor, I'm going to object to the introduction of that email, having read it.
Let's see if she can identify it.
Yes, sir.
He hadn't tendered it yet, Mr. Harrington.
Yeah, this is the email.
All right,
I'd like to enter it as Exhibit 8.
all right. Objection, Mr. Harrington.
My objection to this, Your Honor, is the email specifically refers to what other people who are not here and not subject to cross-examination are saying. She denies what it says.
I'm going to admit it, submit it over objection.
She got, okay, Your Honor.
Respectfully accepted, Your Honor.
In this email chain, do you deny hitting our children?
Yes, I say I don't recall ever doing that.
This is a email that I just sent to her 4 days ago. You stated you don't recall ever hitting the children?
Today? I said, no, I don't.
Email, ma'am.
I think, yeah, I said, I don't recall. I don't. I haven't.
Thank you. Do you recognize this?
Yes.
I'd like to enter this as Defense Exhibit 10.
Objection, Mr. Harrington.
No, sir.
It's submitted without objection.
So what are you doing in Exhibit 10? Are you denying something?
I'm not sure. Can you ask me a better question? I'm not sure what you're asking
No,
me.
sir. No, ma'am, you don't get
Am
to
I-
tell him what to do.
Am I
The only
denying?
person that tells him what to do is me.
Yes, sir.
You respond to his question as best you can. I'm waiting on a response, Ms. Hatzler.
You asked me if I was denying something. No, I wasn't denying something. I was saying the context in which what you alleged had occurred and everything that you were alleging did not occur.
Did you ask our children, put them in front of a camera and record them reciting the act of contrition?
This was part of their religious education as provided by the church, and yes, I did follow that religious education.
You put the children in front of the camera and had them record. I didn't understand your answer, ma'am.
The church required that as part of one of the lessons of religious education through the Google Classroom that they have created was for the children to recite the act of contrition, which is an integral part of the Catholic faith of confession. And one of the things that they were required to do is to recite the act of contrition. And I had it on a screen, and they read it, and I videotaped it and uploaded it as requested by the church through the religious education program. One time.
What does the act of contrition require the reader to do, the reciter to do?
To say that they're sorry for their sins and that they don't want to sin anymore, and because they love God, and that they're going to try to do better. Basically, that's a paraphrase.
What did I ask you to not do in this email?
You asked me not to do the. Can I see it, please? You accused me of emotional and psychological child abuse.
I'm sorry, can you point that out where I make an accusation?
I am writing to demand the immediate cessation of requiring both Oscar and Connor to recite the act of contrition when they have committed no discernible wrongdoing. This practice constitutes a form of emotional and psychological child abuse. You also,
You can read it, the rest of it.
would you like me
It's
to?
admitted, and the court
Okay.
can read it when he is making its decision.
You made a pretty substantial response to that quote, you call it an accusation.
You accused me of emotional and coercion and control over Connor and Oscar through this single act of following the curriculum. And you referenced repeated pressure to confess non-existent transgressions. This happened one time in response to the lesson that was required.
Your response to my request was pretty substantial, wasn't it?
Yes.
How substantial? How many paragraphs would you say are there?
I don't know, 8.
How does that go into the religious stuff, Mr. Kelly? I've already said I'm going to read it and consider it. I'll determine. Yeah, I mean,
I'm making the point that she's denying something in that letter.
and I'm telling you to go on.
She's dancing around something in this letter.
I'm saying go on, Mr. Kelly.
Do the children ever ask you to call me?
Yes.
When do you let them call me?
Usually it's at 7 p.m., but usually when they ask, it's in the middle of the school day. If they ask any time that's not the school day, then I let them call you.
How often do they call you when they're in my care?
A few times a day, up to between 1 and maybe 2 or 3 times a day.
Have you ever told the children no, they can't call me?
Only during school time.
Do they take breaks during the school day?
Yes, but talking to you can sometimes take 30 or 45 minutes, and that's definitely a disruption. And if I try to shorten it, then you file a motion with the court.
This is another discussion about the children's homeschooling. Do we agree that violence is not a good way to discipline our children?
That's what's in our custody order. Yes, we agreed to it.
Approach the witness, Your Honor.
Right.
You recognize this email, Mrs. Etzer?
Yes?
This is Exhibit 11.
Objection, Mr. Harrington.
None.
It's admitted.
What do I ask you for in that email, Mrs. Hetzer?
I'm gonna read it,
Oh, sorry.
and
Are
I'm pretty comfortable I will be able to appreciate what you asked her.
are you in a habit of not directly answering the questions that I ask of you?
No,
when
I
email
try
you?
to answer your questions. Your questions are often
Do you believe,
crazy, and I don't understand them.
Do you believe that you answered my question?
I would need to see it again. I can't. I tried to answer your questions to the best of my ability, including describing the concept of spelling, which is pretty simple, all over again at the very end of the email. Yes, I tried to answer your questions. Are you waiting for an answer from me? I'm not sure.
I asked you a question. You
What
said
was
you
your,
needed
I
to
feel like
see
I've answered the question, so could you please repeat it?
I'm sorry, I've lost my train of thought.
Let's move on, Mr. Kelly. You've got
I
another
have
witness.
nothing further for the witness, Your Honor.
Anything on a cross-examination, Mr. Harrington?
No, sir.
All right, you can step down, ma'am. Call your next witness.
I call myself
Mr. Kelly, I need D9 back.
9.
D9.
I'm going to get out of here with something that belongs to you today.
No, sir.
I doubt that. All right, you're still under oath.
Cindy took the children to church. For years, I've been trying to get the children into church for social programs. And her position is no. The moment she has this final decision-making authority over religious matters, she takes them to church. Well, she takes them before she gets that, but she takes them to church without discussion. Then she decides to have them baptized. You'll see the discussion in that email where she's already made up her mind. She's going through the motions of, do you have any input? I'll ask her all kinds of questions. How do we get from, and that's just one of the emails, but that's the most concise, that she says, thank you for your input, or thank you for the discussion, and we've had no discussion. She chose, the appointment of godparents is a lifelong thing. Children or godparents are required by the Catholic faith. I grew up Catholic. I've been away from the church for 30-something years. The appointment of the godparent is a solemn duty. It's a sacred duty. You have to choose somebody that's going to be there, going to commit to being there. If she dies in a car accident, or if I die in a car accident, they take over as our children's caregivers and are making sure that our children are cared for when we're not available. They're there to teach our children. When I asked her who these people were, she didn't invite my parents, my family, to the baptism. She tells me she schedules their baptism the day after I was arrested. And I don't hear about it until afterwards, because there's a jail communication system that she signed up for it and then removed herself from it. I've contacted the company, and they said that she disconnected her.
Your Honor, I will have to object if he's going
Can't say what somebody else said, Mr. Kelly.
But for the whole time that I'm in jail, she's emailing my email account, knowing that I can't access it, to have religious discussions with me, knowing that I can't respond to it, telling me that the baptism is going on, showing me pictures my email address, pictures of the baptism. When I get out of jail, I ask her, did you invite my mother? She said, no. Only the people that there for the ceremony were invited. My mother calls I ask her who the people are in the photograph. She sent me pictures of Mike and Kim Brox, and I ask her who they are. And she says she said, and I quote, they stood in as godparents for the ceremony. So I asked her, I said, so who are we going to choose for the godparents? She said, I've already told you, Mike and Kim stood in for the godparents. I said, yes, I understand that you asked Mike and Kim to stand in, but what are we going to do about godparents if we're going to go this route? And she says, I've already answered that question. I said, Cindy, just to clarify, you're saying that...
I got
okay.
it, Drill.
And this went
I got
on...
it the first time.
This went on for 9 days.
It's getting late in the evening. If you want to finish up today, we got to...
This went on for 9 days, and she wouldn't admit to choosing godparents.
All right. I understand. She wouldn't commit to the godparents.
Same with religious education classes. Moving them from one church to the next. Anytime I try to be proactive and involved in my children's lives, she tries to interfere and find some way. She's called the police because I took them to church, knowing that I was taking them to church. She called the police and said that I was stalking her. Perry Police Department came down there and said, no, he's not. And I try to make a compromise to get our children back into the religious education classes with their peers. But she won't do it because it's not in her best interest. And I think it's just she's choosing not to agree with me on things. And this was a disagreement that prompted me to file the clarification of your order granting us the permission to modify the 7 p.m. phone call. So that I offered, classes tomorrow night. Let's move our phone call to 8 o'clock so they can go back to the classroom. She said, no, court doesn't allow us to do that. I said, yes, it does. No, it doesn't. Yes, it does. I file a motion that you take me as I don't get it. I get it. She didn't. Everything needs to be by the letter for her. She tries to manipulate things so that if it's.
Okay, I got that. Let's go on to something.
Your order said that we have to do custody exchange at the law enforcement center in the county in which the receiving parent lives. She asks me, where would you like to do custody exchange in Houston County? Would you like the jail or the sheriff's office? I said, I would prefer the Warner Robins Police Department Law Enforcement Center. She says, that's not a county facility, that's a municipal facility, even though it's in the county. These are the word games that she plays all the time. On my son's birthday last year, my mother called twice, texted 3 times. She wouldn't return my mother's phone call to my son, so my son could talk to her on his birthday. Her mother called 1 time and had a conversation with my son on his birthday. When my sons, if they say, I'd like to call mom, here's the phone.
To restore my objection to hearsay, Your Honor, we're getting a little far.
I understand, Mr. Harrington, but I'm going to let it happen.
Yes, sir.
When I'm asked by the kids to call their mom, I give them the phone. They tell me I tried to call, but mom wouldn't let me. They try to call before school. They try to call on breaks, but she won't let them.
I got the calls. Let's go on to something.
And that's it. That's it, Your Honor.
All right, cross-examination, Mr. Harrington.
Mr. Kelly, did the children call you every day?
Yes.
More than 1 time a day?
No.
Just 1 time? Now, during the course of y'all's relationship, you didn't go to church, did you?
No.
You go to church now?
Yes.
Where'd you go?
I study myself. I don't go to a physical church. I participate in online groups and. Our court order, though, it requires that the children be allowed to call at any time that they want to, so long as it doesn't interfere with their schedule.
You would agree that she has a fairly rigorous schedule for schooling during the daytime?
No, I wouldn't agree with that at all.
Fair.
Well, yes, yes, sir, I am. I'm conducting homeschool during my parenting time for a month now.
I don't mean to cut you off or interrupt you. I'm talking about when the children are with her, she is on business on School Beach.
No, she's not. Would you like some examples?
And I cut you off from explaining your answer.
Okay, so no, she's not all business when it comes to school. During school days, when she wanted sex from me, school would wait an hour until we had sex several times in the morning, repeatedly, 2 or 3 times a week. So no, she's not all business when it comes to school.
Just to be clear, I'm asking about time periods after the court's entered its order.
I don't know. I don't know anything about what goes on in her household, except that she doesn't allow my children to call me when they ask
I've got
to.
that. I understand that's your position.
Did I do something?
No, we just have system problems. Go ahead.
Mr. Kelly, even though she discussed these things with you, she answered a lot of your questions, didn't she?
No, she didn't.
And if those emails that you submitted evidence show her answering the questions, you would disagree with that?
I would disagree with it, yes.
Okay.
I disagree that, no, let me take that back. She was answering my questions, but she was not having an adequate, reasonable, or good faith discussion as required by the court's order.
Did you give any alternatives to her religious education in any of those emails?
Not the ones that I presented. Would you like to present some evidence yourself, Mr. Harrington?
No, sir. Mr. Kelly, you answer his questions. You don't ask them to do anything. Do you understand?
Yes, sir. I selected the emails that I thought would best represent our discussions on this topic.
I understand. That wasn't my question. My question is, you didn't provide any other alternatives, did you?
In what context, Mr. Harrington?
Basically, you just didn't want to do it the way she wanted to do it. You didn't give her an alternative.
No, sir, that's not true at all.
Have you presented any evidence otherwise?
Yes, I've given testimony repeatedly about it.
Today, here?
Today and on February 10th and on December 9th. I just remember I filed a motion with this court and asked her to enjoin it. She wouldn't enjoin on it, and the court told me that, no, he doesn't need to clarify his court order, that it was pretty clear. And then I filed another motion to clear up this, to let him know that it wasn't me that was finding his order unclear, it was Cindy. I gave an alternate, I gave an option to her. I said, let's do this. And she says, no, it's not in my best interest.
Well, you've now stopped communicating with her by email.
Yes, 100%.
And the court ordered you to do that, didn't it?
When I have something to communicate to her, I will communicate to her with an email.
Call telling me and sending me correspondence saying you would now send all correspondence to her through me?
If she and I go back and forth 1 or 2 times and we're still arguing, I'm sending them to you. Yes, sir, 100%. I'm not doing the back and forth with her.
Are you sending them to me with the anticipation that you no longer have to send anything to her?
No, I emailed her yesterday. When I need to email her something or communicate something to her, I use email. When we don't have a resolution quickly or we're just going back and forth, I forward it to you and let you deal with it. And if you don't want to address it, maybe in the future I'll address it through a motion. But I'm not going to argue with her through email anymore. She uses email to harass and just harass.
Are you familiar with the email program called Talking Parents?
Yes.
And you have alternately agreed to use that and then disagreed to use that?
Yes and no. She is the one that's refusing to use it now.
Right. Would you agree that Talking Parents allows one stream of emails for the court in the future should it have to straighten anything out?
Yes, I agree with that.
Would you agree, if this court should make it part of its order, to do all of your communication through Talking Parents except in the event of an emergency?
Yes. But the problem is I suggested that, and we agreed to it. And then she said, I will only respond to you through the Talking Parents app, to which I responded, we have a court order that says we must use email. Just meaning that if something happens to Talking Parents, we still have to communicate. And she responded by saying, no, if you're not going to agree to only using Talking Parents, then I'm only using email. She plays games with words.
Let's go on to something else, Mr. Harrington.
So, just a second. What is your problem with the Sheriff's Department in Houston County for the exchange?
Who's indicated that I have I've never indicated that I have a problem with the Houston County Sheriff's Department.
I'm just responding to your testimony. You said you didn't agree with meeting at either the Houston County Sheriff's Department or the jail.
That's not what my testimony was.
Okay. Do you have an objection to meeting at the Sheriff's Department?
We've been meeting at the Sheriff's Department. I don't know what you're trying to, I don't know what you're trying to get at, Mr. Harrington.
I'm responding to your testimony that you wanted to do it at the.
Let's go on.
Yes. That's all I have, Your Honor.
Anything else, Mr. Kelly?
Yeah, so to the point of the not using emails anymore, the email that I presented about Oscar's spelling is the reason why. Like, I'll ask her a simple question and she flips around words like, I just.
I've already got that.
Okay, he brought it up again, so I'm just doubling back.
I know you don't think I've got much intelligence.
I believe you're very capable of reading those emails. I don't know how I don't know what I need to do.
You can go back to the table. Call you next week.
I don't have any more witnesses.
Then those folks can be excused.
Yes, sir.
Tell them they're free to go. Do you need to call them?
I don't need to call them, but one of them wanted to address the court.
Okay.
Do you wish
After
me-
we get through with the hearing, we'll let anybody address the court that wants to address the court.
Yes.
Your Honor, what about the other two witnesses from the sheriff's office?
Mr. Kelly?
I didn't know anybody was here, Jeff.
Yeah, they've been here.
The people that you subpoenaed,
I apologize, Jeff. I didn't know that they were still here. When I
Release Colby and release Lewis.
when he didn't want to hear the testimony, when the judge didn't want to hear the testimony at the start of the case, I knew that I wouldn't be able to call most of these deputies. And I tried to tell her she could go, but he told me that it was up to him.
all right? Mr. Harrington, do you have any additional evidence, Mr. Kelly?
I don't have anything else here.
All right, Mr. Harrington, do you have any evidence you want to present?
No, sir.
All right. We need to have argument on the contempt aspects.
I'll reserve, Your Honor.
Mr. Harrington?
Very briefly, the religious education, I think the emails speak for themselves. I will point out that if he's not doing any form of organized religion and she is willing to do that, this is
Do
not.
what now?
She is willing to do that through.
Do what?
Have religious education through the Catholic Church. If I was indistinct, I apologize.
No, I just didn't hear you. I wanted to make sure I understood what you said.
Yes, sir.
He's misrepresenting what's been tested. That's not what happened. That's not what's going on.
Mr. Kelly, it's getting late in the day, and he gets to argue what he wants to argue unless I say, that's not the evidence, Mr. Harrington. So you don't interrupt him.
Yes, sir.
Go ahead, Mr. Harrington.
As he stated, he has no organized form of religion. He's self-taught, and that is fine. However, she is going to the Catholic Church. It is an accepted and form of religion. The emails speak for themselves, and I can go back and try to parse all that. But she's providing, she did try to talk to him about it. These parties' level of communication is such that they never agree, so somebody has to make the decision, and she is, under the court's order, allowed to make the religious decision. I would argue, not making it independent, she tried to talk to him, it didn't go anywhere. As far as making sure the kids love the other parent, he presented no evidence of that, no competent evidence of that. Court's heard it, I'll let the judge make that decision, as is your purview. And then as far as conflict going on, we're not initiating it, so I would just suggest if he wants this all to go away, a lot of it's within his control.
Mr. Kelly?
I have offered numerous compromises on religious education. And unless it's done exactly her way, she doesn't have a discussion. She stops talking about it. She stops responding. If I don't agree exactly what I've compromised so much, I don't have any soles on the bottom of my shoes anymore from compromising with this woman or offering compromise with this woman. When I was a teenager, I was molested by my Catholic priest. When I told about it, everybody spanked me, told me, "How dare you?" Now, this priest, and their religious education director lied to her and said that I attempted to kidnap my son to cover up their failings to...
That's not in evidence, Mr. Kelly.
He just made...
He hadn't argued anything about that.
He just made an argument that I don't have any formal religion. It's not true.
He made the argument that you do not go to the way I took it was what you testified to, that you don't go to a church. And you don't dispute that, do you?
I was going to a church until she made it a point to tell everybody that I was a bad guy. So every time I showed up, everybody was apprehensive of me.
Okay. Don't know that we had evidence to that effect, but.
She doesn't want a compromise. She wants control. You'll see the emails. You read the emails and you'll see her level of wanting to communicate with me about things. You'll see my level of trying to communicate with her through those emails. And her just, thank you for the discussion. Thanks for the input. Never responding with any substance to anything that I try to talk to her about. When I email her to ask her about schoolwork, and I don't understand something that she's doing, she uses it, she'll send me an email as if it's like, if you can't handle the job, you just tell the court, and we'll petition the court and take it. You've asked for this, now you've got to do it. And she's been doing this for 17 years. In my first week, we had a couple of hiccups, and she's talking about petitioning the court to take away my ability to teach my children at home. Everything is a conflict. I ask her about the kid's spelling that's in evidence, and we have a list that they do every week, that one child does every week. I ask her for clarification. There's two lists, one word, or one list of words, two different documents. My son's telling me I'm using the wrong one, so I ask her. And you see, and if you look at the exhibit, the highlighted part is her previous instruction to me on spelling. That was it. I was asking her for clarification. She can't clarify. I've already told you, I don't know what the problem is, but I was specific.
I get it, Mr. Kelly. I don't know what makes you think repetition gets into my head.
It's not you, it's me. It's being narcissistically abused for 9 years. I feel I have to explain myself to the nth degree because this is what she's done to me.
Okay.
I have to. Because that's what standards she set for me. Our children deserve us to be able to communicate without everything turning into conflict. And we have a huge problem communicating with each other. It's massive. I assume things, she assumes things, and things explode. And I'm tired of it. I just want to be able to have her read what I write and not read into what I write. I want to be able to read what she writes and not have to read into what she writes. I just want peace. I want my kids to be happy, have her and me present, period. And I'm tired of her initiating conflict over nothing.
Okay. All right, I'll reserve rulings on both of these last things like I did the first thing. All right. Evidently, somebody wants to speak to the court, and let's let them speak to the court.
May my remaining two defendants in case
What now?
number 152 come back in the room since evidence is
I think we'll just leave it like it is because I think they were here on this case, Mr. Harrington.
Okay. Yes, sir. Excuse me.
I'm sorry. He wants to address the court for what purpose?
I don't know, but.
In this matter?
I don't know, Mr. Kelly,
I'm going to object to it.
and I'm gonna let him address the
Okay,
court.
that's-
You subpoenaed them to be here. This is the second or third time, and out of courtesy to these people, if they've got a grief, I'm gonna listen to it. You can sit down. I hadn't said anything about I was gonna consider what they said, but I'm gonna give them the benefit of speaking.
Your Honor?
The lady left, but the priest is still out there.
Well,
She was the one that was wanting to speak.
All right, let him come.
Well, he didn't want to speak.
Oh, he didn't want to speak. I thought you said he was the one that wanted to speak. So the lady's left.
Right, she left.
The lawyer's left.
The lawyer's still out there.
He doesn't want to speak.
No, sir.
Okay. Problem solved, Mr. Kelly.
Your Honor, may I please address the court?
Sure.
I chose not to call them because I felt
I
like
don't care what, that's your choice.
I
It
felt
doesn't
like
make any, Mr. Kelly, it doesn't make any difference. It wasn't a reflection on you or anything else. But these people have been here since 1 o'clock. And if they didn't get called, that was your choice. No problem with that. Okay? But if they got something they wanted to tell this court, I was gonna let them talk. But now nobody wants to talk. So you don't have a problem. So, okay? But I'm gonna tell both of you this.
Stand up with the judge addressing.
I may very well reconsider, if I can, the custody order. I may very well go back and revisit it and issue a modified order in that regard.
Do you wish any written argument on?
No, I do not want any argument.
Yes, sir.
This matter's concluded. Have a good evening. Here's what you wanted. You got all your evidence, Mr. Simmons?
Yes,
I need to copy that.
No, we need to give it back to him. Being as though the case is
Mr. Harrington, Mr. Kelly, I don't know whose file this came out of, but it's for affidavit for the, or it's this. I don't know if it came out of your file or Mr. Kelly's
He
file.
handed it up to her, I don't know exactly.
Okay.
Thank you.
Can you see it?
Huh?
Can you see it?
Might rather let
Yeah.
Bob know that this thing froze.